Y'all, it's a lot of mess, honey. I'm trying to pull up, so let me let y'all laugh at this real quick. This phone call with me and my friend today. I take on some music.
You competed with that. So I mean that's why she just said, hell no. Her album, man, she had 8 number 1 songs on it.
Wow.
Yeah, I used to like Aaliyah. I mean, that's like I was telling Sean last night. That's the only female music I have ever brought was Aaliyah. One of the million albums.
Yeah, I remember. You was telling me something about that because, I was trying to tell you she couldn't really sing to me. Now she wants.
Aaliyah wasn't no real good singer. It was just her presence, man. She was cool and sexy with her. You know what I'm saying?
Yeah.
I don't think. And she was kind of like the first one that really don't blow that good, but the music just be real good. So she was like, because I don't think Jennifer Hudson can sing.
You don't think so?
I think she could
sing. She could, she could sing, but I mean, she do a lot of, and she could sing, Tim, because you have to listen to her songs, but she's not doing all that hollering and all those runs and shit.
That's what it was, man.
Yeah, hollering all the runs. I know it is.
Jennifer Holiday was on stage singing. I'm telling you, I'm not going. He was growling and shit. I got so sick of that damn song. And I am telling. I got sick of that damn song.
I'm not going.
That right there, yeah.
Mm-hmm.
Jennifer Holiday. And we went to see New Edition trying to build all that damn growler. I said,
yeah, he done started all that bullshit there. I'm like, Johnny, I ain't never get to meet Johnny.
Yeah, he went in the group.
No, he went in the group. I ain't getting to meet him. That.
Right, I take it back. There's one of them that's still doing it. He's the oldest one out there. Charlie Wilson still making the music.
Yeah.
He saw that night we went to that concert. It was Jodeci and Charlie Wilson and the New Edition. I'm like, why in the hell New Edition coming on out? Charlie Wilson. We this time. But that damn rap was still bad though. Rap still cool as hell. He did what's that song?
I ain't never liked that song.
You didn't?
Mm-mm.
Like the dude say, nigga breaking your house, you let it do to a man. You gonna kneel, you gonna assist in the man thing at the house. Y'all be with y'all ass tore up.
Okay.
But Johnny came out with some bad CDs by himself.
Yeah. I know feel the magic in your touch when I fall and rub you the wrong way. When I fall and rub you the right way. Well, if I found the friend, I'll read out to the end. Even if I'm weather, time and time again, I'll be your friend.
What about this one? Put on your red dress and step in your high heels. Summer that's sweet perfume. It sure smells good on you.
Yes. Woo!
Let all your weed down. And baby, when we get through,
I'm gonna show you tonight with you tonight. So many hard burn. Right now, you got to stay my. So the good to know I'm the word.
You brought in that? You really brought in that song?
Yeah. So damn fine. All you gotta do, say that It's like I'm saying, Mom, Mom, Mama, 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 Mama,
Oh, Lord. Honey. Oh, boy. We talked about some of every goddamn thing today, baby. I told y'all, only people that make me go off is y'all motherfuckers, not everybody else. What's good with it? What's good with it? Oh, Lord. You hated when Johnny joined New Edition. The animals. Honey, we saw some shit today, baby. And we always do our favorite solid, baby. Go with solid. Solid as a rock. Oh, honey. Man, we talked about, cranking it back up, cranking the parties back up. He talked about cheating. I talked about how I was your wingman. Oh, we had a good, yeah, I'm going to have to upload this one. What's good with Atmos? Yes. I see. I heard the first page of your reading, and I had to get to the damn project. So, anyway, it's so much. Oh Lord, I don't know what the other stuff, the other attachments are, but it's probably whatever supporting her argument with this. But oh, child, I'm gonna be here a minute. What's good with it, y'all? What's good with it? Let me get my chat call out the way. Hey, Karen J. Whoa. What's up, Angela Jackson? Hey, Mo. Hey, Cookie. Hey, Optimus. Hey, Miss Tanya. Hey, girl, Melanie. Let me see. Hey, Lady Tech. What's good with it, y'all? What's good with it? So we're gonna see if we can, we can't see the PSI PSR because that is what under seal as like last time, but we'll see if we can kind of figure out what's going on. Now, from what I seen, good old app must read. Oh shit, that ain't the right one. The hell? That Lord, that ain't the right one. Y'all know I'm delirious. I need that's about some damn restitution. That ain't the one I need. I'm rusty already. From what I saw, Atmos read, it seems like Team Kels might be getting a break. Yeah. Yes. Let me see. Seem like Team Kels might be getting a break. Mm-hmm. Okay. Let me put this back. I'll put it up here. Child, we so damn stupid, child. We talked about a whole bunch of stuff. Child, he went to tell me which one of my exes he did like, who he didn't like, and shit. All kind of stuff. We talk about some good stuff. All right, let me see. Let me see. Okay, let me. Damn, my nose. Hold on. Let me blow my nose real quick. Okay, let's see. Let me get this started. Okay. It says, hold on. Now, damn, is that still the restitution? No. Okay. All right. Introduction. Robert Kelly, 56 years old. Hold on. I ain't told y'all what it was. Shit. Okay. Defendant Kelly sentencing memorandum. So this is coming from J-Bo, right? This is a part of her sentencing submissions, right? Which will include the mitigation report, the sentencing memorandum, and whatever attachments or addendums that she seems, that she wants to include, right? To in an effort to mitigate her client's sentence, right? Okay. So this should serve as a opposition to the sentencing, the PSI/PSR. It should always be an opposition because no lawyer is going to be satisfied normally with what time that their client may be facing, right? And when the sentence and submissions come out from the prosecutors, they're gonna have aggregating factors, right? One where they're advocating for a out of the sentence that the PSI/PSR reflect, or something that may be outside the guidelines that may say they want more time, or advocating. It's going to be probably in opposition to the PSI/PSR too, normally, but it's usually, I'll advocate for more time. All right. And the PSI/PSR is always developed by the probation department. All right, it says introduction. Robert Kelly, 56 years old, is currently serving a 30-year sentence of incarceration dispensed by the United States District Court for the Eastern District of New York in connection with the case United States versus Kelly, 19 CR 286. A 30-year sentence of imprisonment for an African American man with diabetes is a life sentence, statistically speaking, because the crimes for which Kelly was convicted in this prosecution could have and should have been brought pursuant to the EDNY Racketeer Influence and Corrupt Organizations Act RICO prosecution. Significant incremental punishment is not warranted, particularly where Kelly is already serving a de facto life sentence. Now, wait a minute. Why she said that? Crimes of which was convicted in this prosecution. Oh, okay. Remember, I said this a few weeks ago. I said that they could have, because I think I was up here talking to somebody about, multiple prosecutions, right, in different jurisdictions or whatever. Right? I think it's probably Skylight. And I said if they wanted to, they could have ran this case with New York, and that would be just one jurisdiction. But because they plan to make sure he never, gets out, they had something in just jurisdiction and something in New York, right? So that's what she's saying. All right, as fleshed out below, the EDNY prosecution charged Kelly with RICO under a theory that he engaged in a pattern of racketeering activity between 1994 and 2018 as part of the enterprise that he had the purpose of recruiting women and girls to engage in illegal sexual activity and to produce child pornography. The charges brought in this district could have been brought in the EDNY indictment, since the conduct alleged in this prosecution occurred during the relevant time period and was covered by the purpose of Kelly's alleged RICO enterprise. Kelly faced a guidelines range of life in prison in the EDNY case and was sentenced to 30 years. As a matter of fairness and double jeopardy, Kelly should not face consecutive sentencing where piecemeal prosecution by the federal government was designed to unfairly enhance his punishment. Okay, y'all. Just because y'all seen the word double jeopardy does not mean that it was double jeopardy. Okay? Please don't run Y'all gonna run with it. I don't know what the fuck I'm saying. Y'all gonna run out the sector with it. It wasn't double jeopardy. Remember, where motions and filing, motions is a filing, but they are persuading arguments, persuading documents, right? When it comes to this submission, it's going to be less factual, okay? And she is allowed to do that because she's not going to be challenged for proof or anything like that, okay? So she is, so please don't run with and say it was double jeopardy because it wasn't, all right? Had it been double jeopardy, they would have had it dismissed for double jeopardy because you can't put someone's life in peril, right? All right, okay, under the law. So please, why you do that, J-Bo? I done got mad, baby, at you. Girl, I'm punching at the damn sky. You know how these people act around here. Okay, it says the federal government's obsession with ensuring that Kelly dies in prison is particularly troubling, where it seems to have no appetite for investigating or initiating prosecutions of numerous other famous white musicians with credible histories of sexually abusing underage women. As set out below, Kelly accepts that he faces a mandatory prison sentence of 10 years in connection with his convictions here. However, Kelly contends that his guideline range is 135 to 168 months imprisonment. The government inappropriately places the range higher at 168 to 210 months imprisonment on the erroneous claim that the inducement counts carry higher adjusted offense levels than they do. So, so apparently on the PSI, the most they're asking, that's why I say y'all getting a break. The most they're asking is 17 and a half years. So between 14 to 17 and a half years. So that's pretty good. Okay, that's pretty good. The government inappropriately places the range higher at 168 to 210 months imprisonment on the erroneous claims that the inducement counts carry higher adjusted offense levels than they do. Because Kelly did not use physical force, threats of force, or tactics instilling fear in Jane, Pauline, or Nia to gain their compliance in the prohibited sexual conduct, the government's effort to artificially raise the offense level of the inducement counts must be rejected. When considering the factors set forth in 18 U.S.C. Section 3553A, including Kelly's significant mitigation evidence and the fact that he is already serving a 30-year sentence for a pattern of racketeering activity that could have been included in the conduct alleged in Northern District of Illinois indictment, a concurrent sentence at the lower end of the guidelines range is sufficient, but not greater than is necessary to comply with the purposes of sentencing. So I told you about the purposes of sentencing. One is to make sure the public is safe, and two is to make sure the public is. It's a couple more than that, but the bare bone is to make sure the public is safe, and to make sure. Well, I can't remember this. I've told y'all this a couple times. Oh, and make sure that the sentence matches the crimes, right? It says a consecutive sentence will serve no specific deterrent, as Kelly is likely to die in prison either way. Oh, that's sad to say. Even if he beat the even if he beats the statistical odds, he would not be released from prison until well into his 80s, long after he is a threat of any kind to the general public. A consecutive sentence serves no general deterrent purposes either, at least no stronger purpose than what has been accomplished with his EDNY sentence, since the government and society at large have reserved a unique, unprecedented contempt for Kelly that is wanting as to his situated white counterparts. In fact, iconic white musicians like Elvis Presley, don't talk about Elvis, who married his 14-year-old girlfriend, are currently being celebrated in Academy nominated movies. In contrast, the government argues that one life sentence isn't enough for Kelly. No one would be deterred by a consecutive sentence in this case because no one believes that they will ever face punishment Kelly has faced for the same exact conduct. Okay, so they must be acting. So the PSR must ask for a consecutive sentence, or she could be stating that. Remember, I told y'all when it's two federal jurisdictions, there's something called aggregate sentencing, which means that it should be concurrent. The judge have to consider concurrent first before. No, I'm sorry, consecutive first before it does. No, yeah, consecutive first before it does concurrent. Okay. So they either ask for it in the PSR, or she is going by aggregate sentencing, okay, which means that it's supposed to be consecutive first. All right, this court is tasked with the sentencing Kelly to an appropriate sentence that addresses the harms a jury found he caused, but an appropriate sentence is a lower guidelines range sentence run concurrent to the EDNY case, which is the functional equivalent of a life sentence. Such a sentence punishes Kelly for conduct that is over a quarter century old while taking into account his individual characteristics that include his own horrific child sexual abuse that shaped him and provide some explanation, not an excuse, for the conduct that underlies his convictions in this case. Brief factual background. Kelly was convicted of 3 separate offenses of 18 U.S.C. Section 2251A, stemming from the creation of 3 videos depicting sexual conduct with Jane, who testified that she was 14 years old at the time the videos were created. The defendant was also convicted of violating 18 U.S.C. Section 2422B as to Jane, with whom he had a relationship that lasted roughly 12 years. The jury returned 2 additional guilty verdicts for violations of 18 U.S.C. Section 2422B as to Nia and Pauline. Nia testified at trial that Kelly fondled her in a hallway at his studio on a single occasion when he was 29 years old and she was either 15 or 16 years old. Nia testified that the isolated encounter occurred the summer of 1996, but she could not state precisely when the incident occurred. Pauline testified that she began engaging in sexual conduct with Kelly when she was 15 years old. The prohibited, Lord have mercy, I don't know why am I messing up with these words? The prohibited sexual relationship endured long after Pauline became an adult, and she considered Kelly her boyfriend. Kelly was acquitted of all remaining counts of the indictment. Argument. A district court should begin all sentencing proceedings by correctly calculating the applicable guidelines range, which should be the starting point and the initial benchmark. Case law. After a proper calculation, a sentencing judge considers the 7 factors set forth in 18 U.S.C. Section 3553A, the nature of the circumstances of the offense, and the history of the characteristics of the defendant. The 4 legitimate purposes of sentencing as set forth below, the kinds of sentences available, the applicable guidelines range itself, and relevant policy statement by the Sentencing Commission, the need to avoid unwarranted sentence disparities among defendants, and the need to provide restitution to any victims. Case law. In determining the appropriate sentence, the statute directs judges to impose a sentence sufficient but not greater than necessary to comply with the purposes of sentencing, which are to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense, to afford adequate deterrence to criminal conduct, to protect the public from further crimes of the defendant, and to provide the defendant with needed educational or vocational training medical care, or other correctional treatment in the most effective manner. 18 U.S.C. Section 3553A2. 1. The guideline sentencing range is 135 to 168 months imprisonment. Defendant guideline range for the instant case is 135 to 168 months imprisonment, not 168 to 210 months as the government argues. All right, so she's saying it's 135 to 168 months. So don't say that's what it is. That's what she calculates it to be. All right? Okay. A. Ex post facto. The government advocates application of the 1997 Federal Sentencing Guideline. Kelly argues that the 1997 Sentencing Guidelines should apply since the conduct for which defendant was convicted occurred prior to November 2000. Probation applies the 2000 Sentencing Guidelines. Probation applies the wrong guidelines, but it does not seem to impact the guideline range. All right. So, which means the guideline range, which means probably the level. Probation applies the wrong guidelines. Okay. Well, then why are you arguing if it don't impact the range? Okay, let me keep reading. B. Offense levels. 1. Counts 1 through 3. The child pornography counts. Base level offense of 27. Adjusted offense level of 29. Defendant agrees with the government that the base level offense is 27, pursuant to guideline section 2G2 1A. Defendants further concede that a 2-level enhancement is appropriate pursuant to section 2G2 1B1 because Jane was over the age of 12 but under the age of 16. This would be true whether applying the 1997 or 2000 guidelines. Number 2, count 9, inducement count as to Jane. Base offense level of 15. Oh, that's low. Adjusted offense level of 15. The base offense level for this count is 15 pursuant to sections 2G1.1, C3, and 2A3.2. Remember, I told you when you see two of those connected S's, that means sections. It means it's going to be 2 or something. Sections, okay? It says the parties agree that the starting point for calculating an offense level for the inducement counts is section 2G1.1, but the parties disagree on which cross-reference subsection applies, if any. Section 2G1.1, C2 and 3 reads as follows. 2. If the offense involved criminal sexual abuse, attempted criminal sexual abuse, or assault with intent to commit criminal sexual abuse, apply section 2A3.1, criminal sexual abuse, attempt or assault with intent to commit criminal sexual abuse. 3. If the offense did not involve promoting prostitution and neither subsection C1 nor C2 is applicable, use the offense guideline applicable to the underlying prohibited sexual conduct. If no offense guideline is applicable to the prohibited sexual conduct, apply section 2X5.1, other offenses. The government notes provide that the cross-reference at subsection C3 addresses those cases where the offense did not involve promoting prostitution and neither C1 or C2 applicable, and includes which prohibited sexual conduct as criminal sexual abuse of a minor under 18 U.S.C. section 2243A. Contrary to the government's position and the positions of probation, hold on. So wait a minute. So is the government agreeing with probation? So if the government is agreeing with 14 years to 17.5, let me not say that till I see their paperwork, because it could be agreeing that is the benchmark, but they could be also asking for the judge to, you know, for like a specific amount of time. Like it might say 17.5, but they may come on and ask for 20 years or 30 years. You know what I'm saying? So let me not say that. I don't know about it. Get happy. Let's see. Okay, it says, let me go back a little bit. It says, contrary to the government's position and the position of probation, Kelly's sexual contact with Jane did not involve an offense of criminal sexual abuse or aggravated criminal sexual abuse, as defined by federal law and the law of this circuit, since it did not involve force or threat of force or the use of fear to engage Jane in the prohibited conduct. Accordingly, cross-referencing to Section 2A 3.1 is prohibited. Section 2A 3.1 of the sentencing guidelines applies when a defendant has committed the offenses of 18 U.S.C. sections 2241 or 2242. CUSSG section 2A 3.1. And that's just the guideline book. All right, it says, comment. A violation of 18 U.S.C. section 2241, also known as aggravated sexual abuse, can be reached when a person knowingly causes another person to engage in a sexual act. 1, by using force against that person. 2, by threatening or placing that other person in fear that any person will be subjected to death, serious bodily injury, or kidnapping. 18 U.S.C. section 2241A. Force is the exertion of physical power upon another to overcome that individual's will to resist. Case law. The Seventh Circuit in 2020 says that it has expressly rejected any interpretation of force to mean psychological coercion rather than physical force. Case law. The Seventh Circuit in 2018 emphasizing that in order to convict on aggravated sexual abuse, the jury must find the defendant used actual physical force against the victim or made a specific kind of threat like fear of death, serious bodily injury, or kidnapping. Section 2A 3.1 of the sentencing guidelines would also apply if Kelly committed a violation of 18 U.S.C. section 2242. Notably, the government did not charge Kelly with a violation of 18 U.S.C. section 2242, and a jury never was asked to decide whether the elements of sexual abuse were satisfied. Okay. A violation of 18 U.S.C. section 2242, also known as sexual abuse, requires the government to prove that the defendant knowingly causing another to engage in a sexual act by threatening them or placing them in fear. Case law. The Seventh Circuit in 1995, the fear contemplated by section 2242(1) excludes such fear that a person will be subjected to death or serious bodily injury, but encompasses the use of any kind of threat or other fear-inducing coercion to overcome the victim's will. Okay, excludes fear by persons of the death. Okay, well, why you use that one? No, as to government's approval, knowledge. Okay, well, let me keep reading because I'm not sure why she used that case law. Okay, it says the record fails to reflect any evidence whatsoever that Kelly used fear or threats to coerce Jane into prohibited sexual conduct. The government never claimed as much as trial. Okay, so she used that to say that it was no fear in either way, either by, threats of force or whatever, or by coercion or, serious bodily harm, injury, death, or anything like that. Okay. Any kind of threat whatsoever. In a highly instructive case, the Seventh Circuit 2021, a jury convicted the defendant, read a law of sex trafficking and forced labor. Law owned and operated 3 massage spas that offered sex services to its customers. Case law. It says 2 of Law's employees, HB and XC, who were born in Vietnam and China, respectively, and traveled to work for Law at her massage spas. They spoke no English and had no support system in the United States. The evidence at trial revealed that once at the spa, Law forced HB to provide sex services to customers by claiming that HB's husband owed her a debt that HB had to work at the spa to pay off Law. Law bullied XC into providing sex services and demanded money for room and board. Wow. HB and XC were pressured into working at the spas under brutal conditions, were not permitted to leave the spas unaccompanied, were denied hourly wages and adequate food. Law confiscated HB's and XC's passport and threatened to have them arrested if they did not comply with her demands to provide sex services. Law also physically intimidated the women. On one occasion, when HB called Law and told her that she was experiencing severe bleeding and feared a miscarriage, Law did nothing and forced her back to work at the spa the following afternoon. On appeal from her sex trafficking and forced labor convictions, Law challenged inter alia, means amongst other things, the district court's application of section 283.1 of the sentencing guidelines, as defendant does here, challenging the fear element of a section 2242 violations. The Seventh Circuit affirmed, finding that Law had placed HB and XC in fear of in a number of ways, including threatening to have them arrested, threatening them financially, and threatening them physically. In contrast, the record is devoid of any evidence whatsoever that Kelly ever threatened Jane or placed Jane in fear or any type of harm. At no point during her days of testimony did Jane testify must be that Kelly made her feel fearful, and that was the reason she engaged in prohibited sex with him. Indeed, the government's entire theory, as kicked off by Dr. Turner's testimony, was that Kelly groomed Jane, manipulated her, and induced her into prohibited sexual conduct through a number of ways. But there is simply no evidence that threats or fear was a tactic utilized by Kelly. Let me get a drink real quick. When asked why she engaged in sex talk with Kelly, Jane responded, I just kind of went with the flow. She said, wait a minute, hold on. I'm sorry. I missed a section. Jane testified about how the relationship first turned physical when she was 14 years old. So we were sitting in the office area of the studio on the couch, talking, watching TV. And obviously we had begun phone sex. And this particular time, it became more physical with touch of the breast and him rubbing on her genitalia area. Jane explained that the sexual contact eventually escalated. That was Jane's testimony. When asked why she engaged in sex talk with Kelly, Jane responded, I just kind of went with the flow. She said he was an adult and that she looked up to him. So again, I went with the flow. Although at one point in her testimony, Jane testified that she participated in the prohibited sexual conduct because of intimidation, she immediately explained that Kelly was an adult and that she looked up to him. She called herself a passive person and stated, I just kind of went along with things and then it somewhat became normal. Jane did not say that she feared Kelly or that he said or did anything to instill any type of fear in her that caused her to have sexual contact with them. When asked to elaborate why she had sexual relations with Kelly, Jane testified, I started having feelings for him. Oh, I was attracted to him in a way, and things were happening so frequently, it was kind of just like being done out of repetition. She testified, I developed feelings for him and I felt good about our interactions, that he loved me, that he would take care of me, that he was my protector. Jane repeatedly stated that Kelly made her feel good. Oh, okay. So she is trying to challenge a particular element of that in that indictment with regards to this particular charge. So that's what she's trying to get that reduced or something here, because she's dealing with one. She's reflecting on R. Kelly's intent, and on the other hand, she's also talking about the mindset of Jane to show that the elements simply don't apply here, or what the prosecution is arguing simply doesn't apply here. And I don't really want to scroll. Well, I'm going to scroll up to see what it was. Hold on. I have to do that. Sorry, y'all. I'm going to get through it. Okay, so you're talking about fear. Okay, hold on. So it must be, is some extra points in here about fear? Hmm. Let's see where she trying to go with this. Okay, although the government may have plenty to say about Kelly's tactics in inducing Jane into a sexual relationship when she was underage, the use of threats or fear was not why Jane engaged in sex with Kelly during the first 5 years of their decade-long relationship. She makes a point. Jane testified that the relationship turned darker after Mr. Kelly was acquitted in 2008. When asked how the relationship changed and when, Jane testified, it changed after the trial was complete. It changed for the worse as far as other women being involved, as far as abuse coming into play, and things of that nature. So Jane was 23 or 24 years old at the time Kelly was acquitted, and when the relationship allegedly changed. A fair and honest review of Jane's testimony leads to the in inescapable conclusion that the applicable cross-reference provision is Section 2G1.1C3 because Kelly's conduct, as described by Jane, arguably satisfied the elements, of 18 U.S.C. Section 2243A, not 18 U.S.C. Sections 2242 or 2241. So she was going after the elements, like I said. Sections 2243A, sexual abuse of a minor occurs when a defendant knowingly engaged in a sexual act with another person who has attained the age of 12 but has not attained the age of 16 and is at least 4 years younger than that person so engaging. 18 U.S.C. Section 2243A. To find the defendant guilty of the inducement count, the jury had to conclude that the defendant violated the Illinois Aggravated Criminal Sexual Abuse Statute, which generally incorporates in different subsections 18 U.S.C. Sections 2241, 2242, and 2243. The government's proposed jury instruction only included a theory related to statutory rape and did not ask the jury to consider whether the defendant used threats or force. The jury was instructed that to find that defendant guilty of the inducement counts, it had to find beyond a reasonable doubt that A person commits aggravated criminal sexual abuse if that person commits an act of sexual penetration or sexual conduct with the victim who is at least 13 years of age under 17 years of age, and the person is at least 5 years older than the victim. So I guess no element of fear. The language is akin to the elements of Section 2243A, not Sections 2241 or 2242. A person is capable of committing aggregated criminal sexual abuse under Illinois law by using threats of force, but the evidence was so lacking the government did not even bother to offer instruction to the jury as an alternative meaning of finding a violation of the statute. So that's what I just said, but they said it more eloquently. So no threats wasn't a part of the elements. Aren't y'all glad we went over elements and the elements and the elements of the elements a long time ago? So it makes sense to you now. It says the record speaks for itself. Jane did not testify that Kelly used threats of any kind or did or said anything that created a fear that compelled her to engage in prohibited sexual behavior. Quite the opposite. Jane described Kelly as showing her affection and love that caused her to participate in the prohibited sexual conduct. That Jane testified that the defendant later engaged in some abusive behavior after he was acquitted in the 2008 is irrelevant to whether he used threats or fear to gain her compliance with the prohibited sexual behavior. Accordingly, there is no evidentiary basis to support the application of the cross-reference section 2G1.1C2. The most applicable cross-reference is sections 2G1.1C3 and 2A3.2, which means that the adjusted offense level for this inducement count is 15. Number 3, count 10, inducement count as to Nia. Base offense level 15, adjusted offense level 15. As was the case with count 9, the base offense level for this count is 15 pursuant to sections 2G1.1C3 and 2A3.2 as argued supra. The record is devoid of any evidence that the defendant used threats of any kind, and fear tactics to engage Nia in the prohibited sexual contact at his studio when she was 15 or 16 years old in the summer of 1996. Just 1 minute, y'all. Nia testified unequivocally that she met Kelly in a mall in Atlanta when she was 15 years old, and he invited her to a concert in Minneapolis. Nia complained that she was attracted to Kelly and had romantic feelings for him. She stated she spoke to him numerous times by telephone, and she felt very good when she spoke to him, and she looked forward to seeing him. Nia testified that she traveled to Minnesota for the concert and called Kelly when she arrived. She attended the concert but only saw him the following morning when he came to her hotel room. Nia testified that Kelly kissed her, touched her breast, kissed her breast, and then masturbated. Kelly told her that he wanted her to come to Chicago, and she accepted the invitation. Kelly did not follow up on the invitation and did not book any arrangements for Nia to come to Chicago. However, Nia made her own arrangements and went to stay with family in Chicago that summer, unbeknownst to Kelly. Nia called Kelly and he invited her to his studio, but made no arrangements for her to get there. Nia convinced her cousins to take her to the studio. Nia arrived at the studio with her cousins, and Kelly showed them around and took them to a waiting area where they could see him record. Nia and her cousin stayed most of the evening, but Kelly was recording and was not hanging out with Nia and her cousins for most of the evening. At some point, Nia was told Kelly wanted to talk to her in the hallway, and Nia went into the hallway to see Kelly. Nia testified he greeted me with a hug, with a kiss, and held. Wait a minute. Oh Lord, wow. And held onto her for a moment, and they kind of made out a little. Nia elaborated. I remember his hand being around my waist, on my bottom, my butt, and then he motioned his hands his hands into my pants as we kissed, and he fondled my chest, and he, kissed. We just kind of made out within the time frame that we were in the hallway. Nia stated he touched my vagina and caressed my bottom, my behind. Nia testified that before she left, she had a similar encounter with Kelly. She stated they embraced, hugged, he held onto me, he held he held my bottom and things of that nature, but it wasn't as long as the first one. Well, okay, she got on there, but I guess she's supposed to be the first one. It was more like, kind of like a goodbye. See you later. Nia never saw or spoke to Kelly again, but in 2002, Nia sued Kelly and the case settled for $500,000. God damn. There is not a single word in Nia's testimony from which any jury or any judge under any standard of proof could find or infer that Kelly used threats or fear tactics to engage Nia in prohibited sexual contact. So the PSI must be have an element for threats in there. So must be in maybe an enhancement or something. Okay, because she's trying to knock something down. Nia was extremely forthcoming when she testified that she approached Kelly for an autograph in Atlanta and that they spoke on the phone, and she was excited when he invited her to to Minnesota to see a concert. So excited that she brought him a red rose on the way there. As to the charge offense in Chicago, Nia admitted that she went to Chicago to see him and contacted him, not the other way around. There was a quick encounter in the hallway at his studio where he fondled her. They embraced and kissed, and Kelly touched her vaginal area. Nia was hurt and upset when Kelly did not return her phone calls after that encounter. The government cannot point to testimony whatsoever that suggests that defendant committed an act of sexual abuse pursuant to 18 USC sections 2241 or 2242. The applicable statute in this case is 18 USC sections 2243, which is incorporated into the Illinois criminal sexual abuse statute on which the jury was instructed. As such, the applicable cross-reference is sections 2G1.1, 2.3, and 2A3.2, which means that the adjusted offense level for this inducement count is 15. Count 12, inducement count as to Pauline. Base level offense level 15, adjusted offense level. Now, please keep in mind that these are her calculations, right? The 15, and where you see these 15, that this is her pencil whipping, okay? As with the prior inducement counts, the base offense level for this count is 15 pursuant to sections 2G1.1, C3, and 2A3.2. Pauline's testimony is devoid of any claim that the defendant threatened her physically or otherwise, or instilled fear in her to gain her compliance in a prohibited sexual conduct. Pauline testified that after she discovered Kelly and Jane engaged in sexual conduct, she began engaging in sexual conduct with Kelly and Jane. Huh? Pauline considered Kelly her boyfriend and stated she loved Kelly. When asked the objectionable question of why she was testifying, Pauline testified that she takes responsibility for having sex with Kelly and that she probably could have just said no, but she loved him. Pauline's testimony at reference 2317, I'm sorry for reading that. It says Pauline offered that she still loves him and that he was like best friend meets boyfriend meets dad in one person. While the government's argument that Kelly groomed Jane and Pauline and induced and exploited them in manipulative ways is fair game, the government cannot convert this testimony into a claim that Kelly used threats or fear to compel the prohibited sexual conduct with Pauline or any other victim. So wait a minute. So she's saying that the manipulation, the being exploited and manipulation is not equivalent to threats or fear. Okay. It says, in addition to the testimony itself, this court should look at the government's closing argument. The government never once argued that Kelly used any types of threats or fear to compel the prohibited sexual activity. There is no evidentiary support for the government and probation's claim that Kelly used threats or fear to gain Jane, Pauline, and Ned's compliance. As such, an offense level of 27, adjusted offense level of 29 for the inducement counts is not permissible. So, okay, so now we know that the PSI, PSR for this particular count is they have it at 27, and then it must be an adjusted level of 2 points to 29. She is coming in and asking for 15s. Okay, so grouping. It says defendant concedes that the production of child pornography is not a groupable offense pursuant to USSG section 3D 1.1, which is just the sentencing guidelines, little manual that goes along with this, and it tells how things should be grouped and all that when going through this particular process, right? It says, notwithstanding that the counts all involve the same victim. Wait a minute, defendant. Okay. All right, because in that handbook, I think it's when it's different victims, then you can't group them, as well as you can't group like certain charges together when they are not related, or if they are related to the same person, depending on what it is, you can group them, but if it's you have to really look at that that little handbook to see if you just want to do all that reading. Okay, you're just that nosy. All right, D, it says criminal history category. Defendant and the government agree that Kelly criminal history category is a 2. Okay, remember New York happened, now this. Probation contends that Kelly's criminal history category is 3 because an unidentified internet source reveals that he pled no contest and received unsupervised probation in 1997 in connection with a simple battery charge. Oh, Lord, probation trying to do him dirty, y'all. and J-Bo said it was a goddamn internet search that they done goddamn use. See, when you get to this phase of it, you can I told y'all, as I told y'all before when we was going through it with New York, you get to use things that you get to kind of freestyle. Okay, you fight for your motherfucking life, so you get to freestyle. Okay, both the prosecution and the defense get to freestyle. They get to talk about different things, right? Certain things within the scope that may not have showed up during trial, but it talks since these things talks about someone's history and things of that nature. Those things are acceptable in these submissions, right, on both sides. Okay, it says, boy, they trying to do them dirty. Probation admits that it has been unable to obtain any court records that reflect Kelly's plea of no contest, his sentence, or proof of how the case was resolved. Instead, it relies on an unsourced internet article containing information that was allegedly obtained from pleadings in a related civil case. And again, pleadings is something that you want the other side to do. A motion is something that you want the judge to do, and a motion and a pleading combined are considered as filings, just like this. I done got thrown off because I can't, oh boy, they tripping. It says probation cannot even identify the internet article on which it relies. Critically, Mr. Alper, who prepared the PSR, contacted undersigned counsel earlier this week and conceded that a law enforcement representative from Louisiana informed him that the arrest and disposition of the 1996 Louisiana arrest was expunged, but Mr. Alper has yet to amend the PSR to reflect that Kelly should not receive a criminal history point from this incident since expunged convictions cannot be counted toward criminal history points. Damn, Mr. Alper. You up there? Baby, I can't stand them motherfuckers in Chicago. I'm going to tell you, with their paperwork, how they file shit and paste and all that, I don't like them. I'm just going to tell you that right now. They ragged as hell. Because they done gave this man, they done bumped this man up a level and shit, which she makes the correct point. Damn. Now that should be taken off, in my opinion. But what the fuck do I know? But that should be taken off because you got to go. You got to look at what are the requirements for someone to get bumped up in categories. And if this was expunged, this does not exist. This didn't result in a conviction or whatever. Then it shouldn't be counted. That's crazy. It says an unidentified internet source is hardly reliable information on which probation should be relying to increase Kelly's criminal history category. In applying the guidelines range must be established by the government by a preponderance of reliable evidence. Remember, relatable, reliable, and relevant. All right. It says 7th Circuit 2022. And actually, relatable, reliable, and relatable, relevant, and reliable is what I teach. The words that's in the actual law. Relevant is one, but the other words are material, and it's actually more, right? I just condensed them down into 3. So she bite my motherfucking word, okay? Reliable. The hell? I was just joking. Okay, it's 7th Circuit 2022. It says USSG section 6A1.3. It says the commission believes that the use of preponderance of evidence standard is appropriate to meet the due process requirements and policy concerns in resolving disputes regarding the application of the guidelines to the facts of a case. The court may consider relevant information without regard to its admissibility under the rules applicable at trial, provided the information has sufficient indicia of reliability to support its probable accuracy. Y'all know I thought that shit was indica from the damn weed strain. Oh shit. I need to get my life together. Hold on. It says 7th Circuit of 2002. Okay, a district court may consider hearsay evidence in determining a defendant's sentence, but the hearsay evidence must be reliable. Hold on real quick. Let me come right now and see if y'all all right, and let me get some water. What's good with it? What's good with it? I'm coming to see how y'all doing. Thank you, Miss Purple. What's good? What's good? Lord have mercy. Hey, Sonya Davis. Hey, Warrior. Hey, Shawty. Let's see who else. Hey, Millionaire. Hey, y'all get them trolls like that, please. Hold on. Thank you. I'm back. What's good with it, Sir Miguel? What's good with it? The Mexican Muslim is in the building. What's good with it? All right. Let me see how many more pages I got. Okay. All right. 17 more. Okay. Probation can offer no reliable evidence that shows that Kelly pled no contest to a simple battery in 1997 for a sentence of unsupervised probation that was not expunged. Indeed, if the incident happened at all, it seems obvious that it was expunged based on the representations of a law enforcement official in Louisiana and the fact that no documents from the proceedings are available. Wasn't that some kind of fight or something? That wasn't no domestic violence on a woman. And I think when there's some kind of fight at a club or something. I heard y'all talking about it one time. Expungement aside, an unsourced internet article that probation cannot even cite based on some information about a civil case that references a prior criminal case is not reliable evidence. Indeed, this evidence is not mere hearsay. It constitutes 4 or 5 levels of hearsay and lacks foundations that since probation does not even identify the mystery internet article that serves as the source of the information. So there's something called double hearsay. Okay. The unknown internet reporter for an unknown online publication obtained information from civil court proceedings or document that apparently referenced a distinct criminal proceeding for which there are no available records, and then reported that information is unknown, unnamed internet article. This information is not sufficiently reliable to raise Kelly's criminal history category. Thus, Kelly criminal history category is 2. Damn. I mean, how he use that? Combined offense level. The combined offense level is 32, as USSG Section 3D1.4 instructs. The offense level applicable to the group with the highest offense level is 29, which relates to one child pornography count. Because Kelly was convicted of 2 additional child pornography counts, which are equally serious, 3 levels are added to the highest offense level of 29 for a total combined offense level of 32. Because the inducement counts have an adjusted offense of level 15 As discussed, supra means above. They do not increase the offense level. Accordingly, Kelly's guideline range is 135 to 168 months imprisonment. Defendant concedes that he is subject to a statutory minimum sentence of 10 years imprisonment. Number two, the sentence should run concurrent to Kelly's 30-year EDNY sentence. Pursuant to USSG Section 5G 1.3c, the sentence in this case may be imposed concurrently, partially concurrently, or consecutively to the prior undischarged term of imprisonment to achieve a reasonable punishment for the instant offense. Application Note 4 directs the court to consider the following factors. A, the type, that detriment in inter indeter, in detriment, parolable and length of the prior undischarged sentence. B, the time served on the undischarged and the time likely to be served before release. The fact that the prior undischarged sentence may have been imposed in state court rather than federal court, or at a different time before the same or different federal court, and any other circumstances relevant to determine of an appropriate sentence for this instant office. But I can't see worth shit. Wait a minute. My damn glasses. Hold on a minute. Hold on, y'all, again. I'm sorry. Let me get my glasses. Hold on. Hey, Miss Denise. How you talking about good night? You just came in here. This 10:31. All right, did y'all need me to reread that? I can see. Nah, I don't need to reread that. Do I need to reread that? Do y'all really want to know? Okay, let me say the sentences should run concurrent to Kelly's 30-year EDNY sentence. Pursuant to USSG Section 5G 1.3c, the sentence in this case may be imposed concurrently, partially concurrently, or consecutively to the prior undischarged term of imprisonment to achieve a reasonable punishment for the instant offense. Application Note 4 directs the court to consider the following factors: the type of indeterminate parolable and length of the prior undischarged sentence, the time served on the undischarged, and the time likely to be served before release. The fact that the prior undischarged sentence may have been imposed in a state court rather than federal court, or at different time before the same or different federal court, and any other circumstances relevant to to determine of an appropriate sentence for the instant office. The foregoing factors mitigate in favor of a concurrent sentence. Kelly has been sentenced to a 30-year sentence, which, as discussed supra, is tantamount to a life sentence. According to according to data compiled by the Sentencing Commission, the average life expectancy of an inmate in general population is 64 years old. Oh God. God damn. Y'all heard that? Wait a minute. Kelly is already 56 years old and has barely begun his sentence. Damn, she done killed him off. Kelly's health issues do not improve his chances of discharging his EDNY sentence. Additionally, the sentence was imposed by another federal court rather than a state court. Oh, okay. So right now she's probably trying to get in, talk about that aggregate sentencing. I told you, the judge is supposed to consider consecutive, right, from jurisdiction to jurisdiction. Okay, but let's see. Unless they change it. Another relevant circumstance for this court to consider is that Kelly's punishment has been enhanced because the government unnecessarily engaged in piecemeal prosecution of him, presumably with the purpose of increasing his punishment. In fact, Kelly's Northern District prosecution arguably runs afoul of due process and double jeopardy principles where the offenses charged in this case were covered by EDNY's RICO prosecution. Because the government rarely, I just said that a few weeks ago. That's crazy that she talks about the same damn thing. Because the government rarely, if ever, prosecutes defendants in separate, simultaneous prosecutions, as the government did here, there is no authority to address whether consecutive sentences would violate due process or double jeopardy prohibitions. However, the Supreme Court decision in Rutledge versus United States case law is instructive. In Rutledge, the United States Supreme Court held that narcotics conspiracy is a lesser included offense of a continuing criminal enterprise and that it is therefore unconstitutional to impose cumulative punishments for both crimes. That means that if one U.S. Attorney's Office prosecuted a defendant for a narcotics conspiracy and another U.S. Attorney's Office simultaneously prosecuted a continuing criminal enterprise that included conduct addressed by the narcotics conspiracy, the sentences would have to run concurrently without violating double jeopardy. Yeah, wait a minute. Now that means that if U.S. Attorney prosecuted a defendant narcotics for conspiracy and another was that RICO? Oh yeah, a continued criminal enterprise. Okay, but they didn't charge him with RICO in Illinois. So I don't know if your argument you're asking the judge to interpret the law there. So I don't know if that's gonna work. It says summarily, the specific RICO theory advanced the EDNY prosecution included the conduct alleged in a Northern District indictment. Okay, see, she used the word theory. See how she tried to get around that? Because I just told you, lady. She used the word theory. All right. So she's definitely asking the judge to um make an interpretation and really think about it that it's actually the same type of conduct. They had employees and all this other stuff, whatever, doing the same thing in Illinois. They just didn't charge them as a RICO. Okay. That was probably by design because they probably most likely could run into a double jeopardy situation, right? All right. Go on, J-Bo, with that word in RICO theory. All right, girl, I got you. The EDNY indictment alleged that the purpose of Kelly's so-called enterprise was to, inter alia, means, amongst all things, sexually abuse minors and produce child pornography between the years of 1994 and 2018. The offenses charged in this indictment squarely fall within the alleged purpose of the RICO enterprise. No logical reason exists for the government's failure to bring the case in a single indictment except to unfairly enhance Kelly's punishment. Even if consecutive sentences would not run afoul of the double jeopardy clause, the sentences should run concurrently as a matter of fairness. The government contends that significant incremental punishment is necessary in this case to account for the fact that this case is different from the New York case in the nature and scope. just used that word earlier. Girls, get out of my head, girl. Here, defendant was convicted of sexually abusing minors, and that abuse occurred prior in time to the abuse of the adult woman and minor victims in the New York case. It says the government is simply wrong. The EDNY indictment speaks for itself. EDNY charged conduct from the 1990s, like that charge in this case, included presenting testimony that Kelly allegedly had a sexual relationship with an underage Aaliyah in 1994, like the government did here. The prosecution in EDNY also presented evidence that Kelly recorded sexual conduct with 17-year-old Stephanie in 1999, which constituted sexual exploitation. The scope of the enterprise covered the exact same time period, and the EDNY prosecutors maintained that creating child pornography and having sex with minors was one purpose of the enterprise. Under those circumstances, there were no reason for the government to engage in piecemeal prosecution except to attempt to enhance Kelly's punishment and perhaps give both the U.S. Attorney's Office an opportunity to hold press conferences. So they got the mouth gone, girl. I like J-Bo. Under these circumstances and the fact that Kelly is serving a de facto life sentence, this court should exercise its discretion and order the sentence in this case to run concurrent to the EDNY sentence. 3. Application of Section 3553A. Factors demand a low guidance range sentence. Section 3553A sets forth various factors that this court must consider in rendering a sentence. A. The nature and circumstances of the offense. Kelly concedes that he has been convicted of serious offenses involving 3 victims, including 3 counts of producing child pornography with Jane when she was 14 years old. The most serious counts of the indictment relate to Jane, with whom Kelly had a 12-year romantic relationship and seemingly genuine friendship until the government indicted Kelly after the airing of Surviving R. Kelly in 2019. Indeed, Jane would have been happy to put her experience with Kelly behind her until the government reviewed the case and insisted that she cooperate with the prosecution, including by inducing her to participate with promises of restitution riches. Listen, just because J-Bo says it here does not make it factual. I told you when this happened in New York, you can kind of freestyle. So please, I know I'm just talking for myself, just blowing it out my ass and my mouth, because you're going to do it anyway. But please, don't act like that this is the truth. Okay? I'm telling you. And what you should be, and this is just a suggestion. Whatever the judge tell you at this level, that should serve as your truth at this level. Okay? Until it gets overturned, consider whatever that judge say is the truth, because that is what's going to be used to bind him, wherever, he may land. Okay? But please, God, I can't believe she's saying this. Damn. As the evidence showed, Kelly and Jane text regularly with one another, attended each other's birthday celebrations, and frequently socialized, including with Jane's parents. When Jane lost her grandmother, Jane encouraged Kelly to reach out to her mother to give his condolences. Kelly assisted Jane with financial needs long after any claims of obstruction could be made, and Jane told Kelly she loved him shortly before he was indicted when she was worried about the impact of Surviving R. Kelly series had on him. Jane admitted from the stand that her relationship with Kelly was close and friendly as of 2019. That Kelly and Jane maintained a close relationship until he was indicted in 2019 is, of course, not an excuse for the offenses for which Kelly has been convicted and will be sentenced, but to ignore that Kelly and Jane's illegal and inappropriate sexual relationship that began in 1997 and morphed into a lengthy relationship between adults who remained close friends until Kelly's indictment in 2019. Indictment ignores the full nature and circumstances of the offenses for which he was convicted. Importantly, it was not Kelly who placed the tapes into the public domain, which may have caused Jane as much harm as the act himself. That Kelly did not produce child pornography for any commercial purpose does not relieve him of criminal responsibility. But if Kelly had been responsible for placing the tapes into the public, the government surely would point to that fact as aggravating evidence. Right. Well, she makes a good point. He did not place it into circulation, but okay, but the elements. I'm talking to myself, y'all. The elements is something else. It was a facility, and it doesn't have to be him. It's the fact that he was on the tape. I'm talking to myself. I'm just trying to right now. I'm trying to separate the elements in the indictment from what she's trying to argue here. Okay, remember, this is freestyle here. Okay, that's what she's doing. So she can talk about stuff that she didn't, talk about during the trial and stuff like that. Okay, so that's where all this is coming in at. She can make these arguments that she's making now that she couldn't make at trial. Let's see. Where am I? It is most certainly relevant that the tape of Jane and Kelly was stolen by her own aunt and given to the Chicago Sun-Times. To understand knowledge, Jane's aunt, Stephanie Edwards, also known as Sparkle, was never indicted for trafficking in child pornography. Get it, J-Bo. Summarily, as to Pauline, she testified that her relationship with Kelly that started when she was a teenager also morphed into an adult relationship in which she loved Kelly. Indeed, Pauline testified adamantly that Kelly was wrong for taking sexual advantage of her when she was underage, but she acknowledged that she loved him and still loves him. Again, though these facts are not relevant as it relates to Kelly's culpability in the crimes charged. I'm glad she said that. So remember when I put it so Levi could understood it. External factors. This is another example of external factors. And you see how she said that the love and all that are not relevant as it relates to Kelly's culpability in the crimes charged. Meaning relevant to the what elements? Got to be relevant to the elements. Or it don't mean a damn thing. It's just talk. It's just an argument. But it's an argument of external factors. That is an excellent way I came up with to try to parse this in Levi's goddamn bald head. Damn. Okay. And skylights. As I said, but they are important factors when considering the circumstances of the offenses and its impact on the complaining victims. Conduct must be considered on a continuum of seriousness, and Kelly's conduct, while serious, did not involve some of the aggravation that is typical of child pornography cases and sex trafficking cases. Finally, the inducement count as to Nia, count 10 is far less serious than the counts related to Jane or even Pauline. Nia admitted that she sought out Kelly. She moved to Chicago for the summer to see him. She insisted on going to his studio, and during an isolated incident in the hallway, Kelly kissed her, embraced her, and touched her genitalia. Nia was either 16 or almost 16 years old when that occurred. Kelly was 28 years old. This this incident did not involve threats, violence, coercion, and occurred primarily because Nia wanted to pursue a romantic and sexual connection with Kelly, as she testified to. Of course, a jury found Kelly of an inducement offense as to Nia, and he faces punishment for that offense. But it does not mean the circumstances of this offense rise to the seriousness of even the other inducement counts in this case. There is no denying that Kelly convictions are serious and the harm caused real, but the government's insistence that there is nothing mitigating about Kelly's conduct or life is inconsistent with the actual evidence presented at trial and heard by the jury. B. The history and characteristics of the defendant. Defendant is widely accepted as a musical genius with a rags to riches story. He is considered the greatest living R&B singer and has earned multiple Grammy Awards. He has written and produced music for celebrated artists like Michael Jackson and Whitney Houston. Notwithstanding his legacy status, Robert Kelly is a man with a complicated story that is highly relevant to this court's goal of fashioning an appropriate sentence for him. Defendant has been portrayed by the government as the media as a one-dimensional villain, undeserving of any measure of humanity or dignity. This court is charged with considering defendant's unique history and characteristics in rendering an appropriate sentence. Defendant's history and characteristics reveal that he is not an evil monster, but a complex, unquestionably troubled human being who faced overwhelming challenges in childhood that shaped his adult life. This evidence is critical to understanding how and why defendant finds himself in the current situation. Okay, don't write that lady office. Don't go harassing that goddamn lady. She has to say something, okay? Because, listen, she got to get as low as she can get, all right? She had to carefully word this. And it's not, as you see, it's not admitting any guilt. But remember, she still has an appeal out there that's going to come, all right? So she has to word this in such a way to try to get some type of leniency with regards to his sentence, okay? So you can't word it, oh yeah, I ain't do this, I'm I'm innocent, blah, 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 and this, that, and the third, whatever, because that can contradict with the appeal, okay? With what needs to be said on the appeals. But like I said, with the appeals, it's structured, right? It's only certain reasons, certain errors that you can bring upon appeal. All right, you accepting responsibility, whatever at this time, then you go in and appeal, say, oh, but that doesn't. Okay, I explained that last time this happened. Go see that video. Okay, in this vein, the court must consider the offenses at issue in this case are 25 years old. Contrary to the government and probation's contentions, Kelly did not engage in a pattern of creating child pornography after his state court indictment in 2002. While Kelly was not a child in the late 1990s, he was also not the middle-aged man he was at the time of the 2019 indictment. In the mid to late 1990s, the time of the underlying conduct, Kelly was a damaged man in his late 20s with an extraordinarily traumatic childhood that he failed to confront. He lacked the insights or ability to appreciate the ways in which his traumatic childhood impacted his unhealthy sexual development and harmful choices. As acknowledged in the pre-sentencing investigation report and set out more fully in extensive reports prepared by Dr. Park Dietz, MD, that's the same man they used last time. He got all those signatures and shit. And Dr. Renee Sorrentino, MD, defendant experienced a traumatic childhood involving severe, prolonged childhood sexual abuse, poverty, and violence. His victimization continued into adulthood, where, because of his literacy deficiencies, Kelly has been repeatedly defrauded and financially abused, often by the people he paid to protect him. Dr. Deet's report focuses on Adverse childhood experiences, illiteracy, and Kelly's positive character traits. Incorporated into Dr. Deet's reports are findings of Dr. Daniel Martell, PhD, who conducted neuropsychological testing of defendant. Dr. Sarantino's report contains a complete history of Kelly and focuses on Kelly's sexual history, including a detailed discussion of the sexual abuse he suffered as a child. Dr. Shantae Alexander conducted collateral interviews in connection with these reports. The reports are lengthy, and the defendant will not quote from them extensively, but will highlight certain portions. Critical to understanding the history and characteristics of the defendant is understanding the traumatic childhood that shaped him. Dr. Deetz writes, traumatic childhood events such as abuse, neglect, and witnessing experiences like crime, parental conflict, mental illness, and substance abuse can result in long-term negative effects on learning, behavior, and health, often referred to as adverse childhood experiences, ACEs. These types of events create dangerous levels of stress that can derail healthy brain development and increase risk for smoking, alcoholism, depression, heart disease, and dozens of other illnesses and unhealthy behaviors throughout life. Dr. Deet opines that Kelly endorses a significantly high number of adverse childhood experiences that cannot be overlooked when considering his history and characteristics. Dr. Deetz writes, many of Mr. Kelly's problems are now known to be adverse outcomes associated with cumulative ACE, including but not limited to the below average academic and literacy skills by kindergarten age, lower school engagement, learning behavior problems, not complete high school, sexually transmitted disease, having 50 or more sexual partners, anxiety, panic disorder, and criminal conviction. Separately, there is now substantial evidence that a history of being sexually abused as a child associated with subsequent convictions for sexual offenses. As set forth in detail in Dr. Deet's report, Kelly grew up in poverty and experienced a chaotic home life. One of his longtime employees and friends aptly writes in a letter of support, Robert was born in poverty, but even as a kid, he had a passion for music. He shared with me some of his abusive circumstances he grew up in. It was a horrible environment for any child, and Robert is amazingly resilient to have even survived it. As a young adult, he was homeless and earning money as a street performer on the frigid streets of Chicago. Eventually, his hard work and talent earned him a record deal, but the deal wouldn't take away his illiteracy or the traumatic experiences he endured. Kelly never knew his father and was raised by his mother and stepfather, who by all accounts, were heavy drinkers and would sometimes violently fight. During one vivid fight, defendant's stepfather pushed his mother and her dress got stuck in a car door before defendant's stepfather drove off, dragging his mother, oh my God, for a short while her sons threw bricks at the car. By objective accounts, Kelly and his two brothers suffered physical abuse at the hands of their mother, who disciplined them with whippings with cords and switches. On one occasion, Kelly's mother grabbed a knife to threaten Kelly and his brothers and accidentally stabbed Kelly in the left arm. Neither Kelly nor his brothers considered the punishments meted out by his mother as abusive. Indeed, Kelly's mother was beloved by her children. Kelly lived in a violent neighborhood with significant gang and drug activity. Kelly steered clear of gang and drug pressures, but still witnessed significant violence that made a lasting impact on him. For example, at the age of 14, Kelly was shot in the arm with a .22 round while riding his bicycle down the block. Critically, Kelly experienced multiple sources of childhood sexual abuse and premature sexualization that sheds significant light on some of his behaviors. Dr. Sorrentino and Dr. Deetz write at length about how Kelly was sexually abused as a child for many years by his older sister. Both of Kelly's brothers report being sexually abused by their sister. Both of Kelly's brothers. Oh. Defendant was also sexually abused by a landlord and family friend known as Mr. Henry. When Kelly was only 6 to 7 years old, his sister started molesting him. The abuse included oral sex and intercourse and persisted into middle school. Kelly's sister began dating their first cousin. Wait a minute. Wait a minute. Kelly's sister began dating their first cousin, Lewis, and she would have Kelly take Polaroid photos of them having sex. Mr. Henry sexually abused defendant on a weekly basis during the same general period of time. My God. Whew. The abuse included oral and anal sex. Oh, oh. Dr. Sorrentino opines that defendant's history of childhood of sexual abuse should be considered a mitigating factor in his sentencing hearing. It is my opinion with reasonable medical certainty that Mr. Kelly's history of childhood sexual abuse is consistent with the definition of mitigating factors as any fact or circumstance that lessens the severity or culpability of the criminal act. The following evidence supports this opinion. Mr. Kelly's history of childhood sexual abuse represents a hardship or circumstance that was out of his control. Number two, this history has been described in scientific literature as contributing to adult hypersexual behaviors. Number three, Mr. Kelly's adult hypersexual behaviors were factors in his criminal convictions. Defendant suffered other childhood trauma, including witnessing the drowning death of his first childhood girlfriend, Lulu, when they were 8 or 9 years old. Defendant and Lulu lived in Chicago Heights and were walking near a river when another boy pushed Lulu into the river. Defendant did not know how to swim and began screaming as he watched his friend drown. My God. Boy, that tears me down every time I read that. Multiple sources confirm this traumatic event and opine that it had a significant impact on Kelly. Kelly is functionally illiterate. Kelly's inability to read and write as a child was a significant source of shame and embarrassment that persists to this day. Kelly was bullied as a child because he could not read or write and eventually dropped out of high school after being held back several times. Kelly spoke of the shame and fear he experienced later in life when accepting Grammy Awards since he could not read the teleprompter. At the time of the underlying offense, Kelly functioned and still does to some degree as a much younger person than he actually was. Even Lisa Van Allen testified that she and Kelly connected because they shared the same interests despite their significant age difference. Kelly's intellectual disabilities shed some light on why he engaged in inappropriate relationships. Dr. Dan Martell re-examined defendant and reported that he has significant impairments in all areas of academic functioning. Lord have mercy. Placing him in the bottom first to third percentiles and at the early elementary school level, i.e., first to third grade overall. Dr. Martell's testing indicated that Mr. Kelly's cognitive abilities are not evenly developed, such as that his full scale IQ, which fell in the borderline range of FSIQ 79, does not adequately reflect his overall level of intellectual ability, which is more likely in the low range, in part due to his lack of school learning. Defendant's literacy deficiencies have led to chronic victimization in adulthood. Defendant has been financially exploited in his entire adult life. At one point in his career, he was told he was worth $900 million. He is now destitute. Dr. Dietz also detailed a number of positive attributes of the defendant as reported by collateral sources. Defendant is by all accounts, a generous and forgiving person. Defendant has employed his family and friends and continually reemployed them after they stole from him. One of defendant's friends recounts, he really has a good heart. He's not a bad person. He has a real forgiving heart. People that did things to him, people around him that sued him and came back and he forgave them and gave them their jobs back. And he's real. He's a real kind-hearted person. Another friend described defendant as follows. He is compassionate and empathetic. When Robert learned of a shooting that took place that claimed many lives and devastated a small community in Virginia, he stopped what he was doing and wrote a song called Rise Up, which to this day is still played, and every penny of the proceeds is shared by the families, the college, and the community. Another time I recall worth honorable mention was when Robert saw on the news that a horrific incident had taken place at the E2 nightclub in his hometown. There had been a stampede where 21 people were trampled to death. Robert gave 21 families whom he did not know money towards funeral expenses. Defendant is also described as down to earth and someone who eschewed the celebrity life, more comfortable keeping close to the community of his childhood. Reports from Dr. Deese and Dr. Sorrento and supporting letters provide additional and significant evidence of defendant's history and characteristics. C. The sentence must be significant but not greater than necessary to satisfy the sentencing goals. The court shall impose a sentence sufficient but not greater than necessary to comply with the purpose of sentencing as set out below. 1. Reflect the seriousness of the offense, promote respect for the law, and to provide justice punishments for the offense. A sentence at the lower end of the guidelines range would reflect the seriousness of the offense, promote respect for the law, and provide just punishment. Kelly has already discussed at length the nature and circumstances of the offenses. At bottom, Kelly engaged in prohibited sexual relationship with Jane and Pauline starting in the 1990s. Unfortunately, Kelly was not the first or the last man to engage in sexually prohibited relationship with a teenager. Frankly, most men who engage in sexually prohibited relationship in the 1990s and before have never paid any consequences for their actions, let alone facing a sentence of life in prison. Any sentence of imprisonment for a 25-year-old conduct reflects the seriousness of the offense and will promote respect for the law in light of the government's apathy towards such crimes prior to the Me Too movement. Wait a minute, what's that? Wait a minute. Okay. Frankly. Okay. Moreover, Kelly is already serving a de facto life sentence for conduct like that charged here. Any sentence of imprisonment promotes the respect for the law where Kelly is likely to die in prison no matter what this court sentences him to in this case. Number 2, to afford adequate deterrence. Veterans. At the outset, Kelly's 30-year sentence in connection with his EDNY already solves any specific deterrence consideration since Kelly is unlikely to survive prison. The defendant is serving a de facto life sentence in connection with his EDNY case, where the life expectancy of the general prison population is 64 years old. Kelly is 56 years old. The United States Sentencing Commission preliminary quarterly data report indicates that a person held in general prison population have a life expectancy of about 64 years. Case law. The Seventh Circuit of 2007, acknowledging the decreased life expectancy for incarcerated individuals based on United States sentencing Commission data. Kelly would have to defy all statistical odds to make it out of prison alive. Kelly's existing 30-year sentence has assured that he will have no opportunity to commit any crimes in the future. In the unlikely event that Kelly was to survive his 30-year sentence, there is no reason to believe that he would reoffend as a geriatric in his mid-80s. The overwhelming majority of Kelly's criminal conduct was committed a quarter century ago, as Dr. Dietz and Sorrentino confirmed. Kelly is not a pedophile despite his convictions for child exploitation, where his youngest victim was Jane, who was a prepubescent minor. As Dr. Dietz and Sorrentino confirms, a defendant is not a pedophile, which is a diagnosis that Kelly has never received. Dr. Sorrentino opined, I consider this diagnosis of pedophilia given Mr. Kelly's alleged history of sexual contact with minors. The diagnosis of pedophilia is used to refer to individuals who experience recurrent, intense sexual arousal, fantasies, or sexual urges involving sexual activity with prepubescent children or children, generally aged 13 years or of 13 years of younger, 13 years or younger. Maybe that's for me. I rejected the diagnosis because Mr. Kelly does not report a history of sexual arousal to a prepubescent individual, and his sexual behavior has never involved prepubescent individuals. In sum, no sentence is necessary to specifically deter Kelly since he is already likely to spend the rest of his life incarcerated. Whatever sentence this court imposes on Kelly, whether it is a 10 years imprisonment or something greater than 10 years imprisonment, the sentence will afford little deterrence to the general public because the general public has no reason to believe that they would be targeted for prosecution and enhanced punishment as Kelly has. The following iconic music artists, Bob Dylan, Elvis Presley, Jerry Lee Lewis, David Bowie, Jimmy Page, Bill Wyman, Ted Nugent, Steve Tyler, Mick Jagger, Iggy Pop, and Marilyn Manson have all been accused of abusing underage girls. None have been prosecuted and none will die in prison. The government has shown a unique appetite in prosecuting and punishment Kelly as compared to his white counterparts. Thus, it is unlikely that Kelly's sentence will have any deterrent effect on the general public. It surely will have no additional deterrent effect than does Kelly's existing 30-year sentence. The general assumption is that the government would not prosecute anyone but Kelly as harshly for similar conduct. To have a deterrent value, the general public has to include that they too could face the consequences that Kelly faced if they engaged in similar conduct. The government's failure to focus its attention on other artists and musicians with similar backgrounds to Kelly fails to leave the general public with the impression. 3. To protect the public from further crimes of the defendant. Whatever sentence this court imposes will do nothing to protect the public since Kelly has already been incapacitated by a sentence that is the functional equivalent of life given his age. Kelly has already addressed this sentencing consideration in the preceding section in connection with discussion about specific deterrents. Number 4, to provide, hold on, my remote, I think, to provide defendant with needed treatment. As stated already, Kelly already sentenced to a term that amounts to life sentence. His sentence affords plenty of opportunity for Kelly to obtain treatment in prison, with which he would comply, but he has little to no chance of being released from prison. As such, this factor is irrelevant. A concurrent sentence at the lower end of the guidelines range will unlikely change Kelly's fate, but it leaves a sliver of hope that Kelly may survive prison and have the change to die, maybe the chance, okay, you got change in there, the chance to die outside prison walls. That is the best Kelly can hope for absent reversal of his EDNY conviction. The Section 3553A factors, and specifically the mitigation presented to this court, demands that Kelly be afforded that tiny chance of leaving prison someday he far when he far too old to be any risk of harm to anyone. When he's far too old to be of any risk of harm to anyone. In conclusion, for the foregoing reason, defendant sentencing range is 135 to 168 months imprisonment. A concurrent sentence at the lower end of the guideline range is sufficient, but not more than necessary to satisfy the sentencing goals. And it was some some footnotes I wanted to read. All right. Okay. Number one, the United States Sentencing Commission preliminary quality data report indicates that a person held in general prison population has a life expectancy of about 64 years. The range is certainly not as probation contends, where probation clearly did not read the testimony of the complaining victims, ripped much of the PSR from the EDNY case, and demonstrated a concerning bias where it attributed a criminal history point to Kelly based on an unsourced internet article. It is in its recommendation of a maximum guideline sentence. Probation did not even accurately summarize the conduct for which Kelly was convicted. For example, probation summarized conduct related to Nia that was neither pled in the charging instrument nor related to the count for which Kelly was convicted. Probation claims that Kelly's conduct against Nia was not a one or two time occurrence when it was precisely a two-time occurrence and did not involve anything more than touching. In its recommendation, probation relied heavily on facts that the jury expressly rejected and even invented facts that were never alleged by anyone. Now, the prosecution, if this is the truth, the prosecution should do the right thing and correct it. What I mean corrected, when they submit sentencing submission, they should disagree with the PSI, PSR, and pretty much just go back over these calculations, because she is alleging some stuff here that, if in this instance, if she's not telling the truth about this and alleging that she has facts to support what she's saying, then she is crazy as hell. Okay? But the government should come and correct this, because this is crazy. I don't know what them motherfuckers be doing in Chicago. I already got an idea of that goddamn school system, but I don't know what, this is awful. Damn. A jury rejected the government's evidence that Kelly enlisted people to retrieve contraband. The jury acquitted all three defendants of receiving child pornography, which demonstrates that the jury clearly rejected the government's claim that Kelly enlisted persons to obtain any tapes. Probation seems to have blatantly ignored the jury's verdict to the extent that it benefits Kelly. Probation even boldly claims in its recommendation that Kelly began blackmailing Jane. This is nothing short of a fabrication. In sum, probation did not do its job. It demonstrated extreme bias and a lack of competence in putting together the PSR, right? And its recommendation should be ignored. Dang. That's just ridiculous. I mean, goddamn, you got a app on the goddamn thing. Just put the shit in. Hell, and then you know pull out the whatever you're using for to do the enhancements and shit like that. Whether it be the if you're just going by the testimony, if you're reading through all the testimony, or including the indictment, which is what you're supposed to do, all of that to make your enhancements to see what it should be lowered and all this and that, whatever, don't just half-ass it. Like, damn. Demonstrating probation's clear bias against Mr. Kelly, Mr. Apper told undersigned counsel that he was trying to get further information about the expungement with the help of the government. Mr. Apper explained in sum and substance that he couldn't just rely on the hearsay statements of a law enforcement official in Louisiana. That's just not how we do things. Only it's exactly how probation did it when they hit Kelly with the criminal history point based entirely on an unsourced internet article. Presumably, the hearsay statement of a law enforcement officer is more reliable than an unidentified internet article. Presumably, the hearsay statement of an is not more reliable. Must be she meant to be. It's not more reliable. The hearsay. Okay. Apparently, hearsay is only unreliable to probation when it works to the benefit of Mr. Kelly. Right. So she did that sentence prior wrong. Why you got to proofread? Kelly has attached the mitigation reports that were prepared in connection with his EDNY sentencing that occurred last June. Kelly has redacted those portions of the expert report that relate solely to the EDNY case. Kelly was unable to retain the experts to modify or amend the reports specifically for use in this case due to the lack of resources. Even if Kelly had access to resources, the government has restrained his ability to use any resources for his defense. The reports are relevant to the extent that they speak to Kelly's personal history and characteristics. Okay. Let me see what that other stuff was. I think that other stuff was exhibits and shit. Right. So I don't need to read that because that's the stuff from EDNY and testimony and stuff, which we already went over. So let me come right now with y'all. So what's good with it? What's good? Let me holler at some more people. Hold on, wait a minute. Is anybody in cussing me out? Wait a minute. Oh, wait a minute. I'm speaking to you, Phyllis Evans, right now, because I don't know if you're going off on me or whatever, because you know what? I don't go off on. I don't go off on people anymore. I'm back to the Zen and yeah. New Black, what's good with it? Hey, Mark and K. Okay. So let me go and drop the link. Yeah, so the government should do the right thing and correct that. If this is true, okay. Thank you. What's up, Phyllis? Then the government should do the right thing and correct that. That's crazy. And that doesn't mean change. They can't change the report. That's not what I mean. But what I mean in their submission, right? It's gonna be the same thing. They should disagree with the PSR report in the areas in which it is not truthful. Okay, relying it's relying on information that's not factual. Okay, because that's not right. You don't do that. Some bullshit. I'm trying to get the link. Oh, thank you, Phyllis. Yeah, that's really shady. That's some shady shit. Like, who does that? Like, why would you do that? Like, why in the hell would you do that? I do not know. That is crazy. That's crazy though. So what y'all think? What y'all think? Oh man, I can't hardly tell what the shit was now. Cause in all the spots, right? She didn't put like what the probation report was, and she just mainly had her calculations on there. She didn't put what she disagreed with the probation report. Right. That's crazy about that article. They're not going to take, the probation, Mr. Alper, not going to take the word of the law enforcement person in Louisiana. But what's good with it? What's good with it? My partner in crime, the fella from Detroit. What's good with it? What's going on?
How you doing, Ms. Walker?
All right, what's going on?
Man, I tell you this. You, Atmos, what up, Atmos, if he's still in here? Mr. Niece, how you doing, Mr. Niece, if you still in here? You, Atmos, do I have an echo?
You good.
You, Atmos, Mr. Niece, and several others. You wouldn't survive 5 days in Detroit, what you're thinking. Asking for you wouldn't survive 5 days for where I grew up. You wouldn't survive 5 days where I grew up, asking for people to be fair and I think the government
Oh no, you better call me naive again, because I get it about 2 or 3 times a day. You naive.
Atmos over there calling people brother who threatened his mama and shit. I ain't never seen nothing like y'all. Miss Denise finally got a taste of it when the pap smear lady went crazy. Oh my God, I ain't never seen nothing like y'all. Y'all wouldn't survive 5 days in my city. Let me tell you something. In Detroit, you give us a certain look or don't say nothing. It's for life. You understand? It's for life. Like when you let us know where you stand, that's where you stand forever. You feel me? You would have to you would have to open a church, become a priest or a pastor, get baptized 3 or 4 times, repent, stand on the corner on your knees before before we believe you.
Right.
You feel me? Once you have said something, it's up. But let me say this, as it pertains to
This woman, let me answer this. Shawty, I said I think they're asking between 14 and 17.5. I was trying to figure it out, but I really can't tell. So I wanna put a pin on it because they can come back and say they're asking for a little bit, that might be the benchmark for them, but they may ask for a little bit more. Okay, so I don't want to say it yet. I knew I wasn't gonna be able to get a handle on an idea on it until they put theirs in, or because before with New York, by this time, honey, we knew what the PSI said. We knew what New York. We knew what the defendant was and what the defendant was asking about, and we had a good idea we had an idea what the damn prosecutors was asking for before they put their submissions in and shit. And this is all over the place, so I don't want to say nothing. Go ahead. I'm sorry, Levin.
Oh, no problem. The PSR, the probation department, the PSR report, being insufficient, flawed, inaccurate, or whatever you want to call it. Once again, listen, man, I don't get. I'm just a different kind of person, Ms. Walker. Listen, I am. I was listening to you. I was like, don't she understand?
What do you mean? Don't understand?
Ms. Walker, when you said two things, you said with the PSR report, you don't just go in willy-nilly and just put unfounded facts when it comes to determining a person's life. I'm paraphrasing, by adding points based on rumor, conjecture, lies, innuendo, or just a bunch of what you think. Well, hearsay. Well, we heard that he pled no contest, so we just gonna throw it in there. Well, that's no different than.
Hold on. You can, but in these reports, you can add in hearsay. But here's the thing: but people got to come back and challenge it or whatever. See, when you get to this part, they get to talk about stuff. They want you to consider factors that you may heard or you may not have heard in court. Okay, and it doesn't really have to be supported by anything until somebody start challenging it or whatever, making them prove it and shit. But go ahead, yeah, it's kind of willy-nilly.
Yes, ma'am. From my understanding, when a PSR report is submitted, it must bear the characteristics of everything being factual, because we're talking about points that can determine how long a person is incarcerated and really determine a person's life, their life. Impact their life in such a way, every point matters. I've said it before that this has always been a game of inches, like football, like the Super Bowl. So to make sure you're clear, I want to make sure I'm clear. I understand that hearsay, there's a little leeway for hearsay. However, I thought that leeway was given to the prosecutors and the defense, not the damn probation department, the pre-sentence report.
No, 100%. I'm 100% accurate on the PSI, PSR. It can contain hearsay, but they'll just, it's just subject to be challenged. And I told you that right off my dome. Anybody want to look that up? Go right ahead and look that up and put it in the chat. Go ahead.
Well, I'm not. I believe you. I believe you.
I know you're not, but I know you because I know you're a person that processes logic, and you process your logic based on what you think is right, and I get that. Yeah. And I know it sounds crazy because I had to explain this last time this happened. I know that sounds crazy, but they will, because this is you're back at with arguments, but you can argue things that was on the record, wasn't on the record, hearsay, how you feel, this and the third.
Yes.
Look up, can a PSI report contain hearsay? See if it'll tell you that. And get it from a reliable source.
Yes. However, now you see what I've been saying for years as it pertains to I myself believing in a thorough process, a very thorough process. That's just me. However, I want Team Truth, Old Cove. They get mad when I call them Team Truth. I be playing with them. Team Truth / Old Cove, Larry, Tears, Ty. I want y'all to turn y'all devices up loud. If you're watching Miss Angie on television, take your remote and turn it up. So I got something to say. I think by what Miss Bonjean just reminded the court of, I think that you all, as the I think you said I don't know if it's probation or prosecution needs to correct some things. I think that Okove and Larry and Ty and Tears and Blade and Diva, y'all listening to me? Y'all need to come back. If you're noble, decent, intelligent, principled people with integrity, you should come back and say, well, we were wrong. Because Ms. Bonjean reminded the court that even the doctors said that my cousin does not classify as a pedophile and gave the clinical definition, which is carved in stone, that from their assessment, he had no issues with being aroused with children. Now I understand that children word is interchangeable and is up for interpretation. You know, I call a 20-21-year-old a child. Like, child, you better go on. So, in short, the pedophile, all of that right there has, that's senseless. That's just slander. Also, I want to say that, when you admonish or even though it may, what's up, Skylife?
What's good?
What's going on?
I'm letting you get. I'm just gonna come in for a little quick and then I'm gonna get out. Won't let me just let you.
Well, no, I'm good. I'm not gonna be long, believe it or not. But the fact that be it jokingly or not, that you put that in when you were speaking, you shot a little admonishment. You admonished the terrorists when Miss Bonjean started saying things that made it appear that she was being condemning of Robert. When you said, okay, don't go, y'all calm down, but I tell you, it's inevitable, Ms. Walker. It is inevitable that they're going to attack her. They're going to turn on her. If you look at the pattern and if you look at the history, eventually they will be attacking her. The same people that's sitting there talking like they love her so much. These are terrorists. These are people who have no other way of addressing anything but to attack and to viciously critique. Now go on, Ms. Scott, because I don't want to hold you. So go ahead. What you need to, what's going on?
Okay, let me say this now, and I have to start where you started, because Angie and her friends, you all really believe that this whole legal process, the takedown of Kels, has been done righteously and in the spirit of righteousness. So you act as if you shocked to find out that they possibly have made a over request of time for him, as if that's not the agenda to take him down any way possible from the get-go.
Absolutely.
No, I'm not saying, I never said that the system does not have mistakes and shit don't go right. And and they, you know what I'm saying. But listen, but what y'all fail to believe that trying to take somebody down is not against the law.
But if it's not done justly and in a legal, quote unquote, that's y'all word, in a legal matter.
Right. That's what it has to be done by. Trying
Right.
to take somebody down is the actual, there's the what you're supposed to do.
But I thought you said you're not supposed to break the law. So
Yeah, you
how
can't break. No, you're not supposed to break the law. That part is correct. But
okay.
I know a lot of people always hollering, "Oh, they trying to take them down. They trying to take." Well, yeah, that's the whole purpose.
But I'm saying, but you're gonna overcharge, create narratives and spin the facts all in to take them down. I'm just saying it's just amazing how you all and people in the chat also probably believe the same thing, that everything, like, you're shocked by any of this.
Absolutely.
I'm not shocked at all. So
I'm shocked.
Absolutely.
I'm shocked that a probation report would be, if it is true what she alleged, that would be so careless. I mean, now you can. I mean, like I said, you can freestyle on these things, but goddamn, to bump somebody's category up, that's not.
but,
Come on now.
but if you look at the words you use, you said careless. Why not intentional?
Absolutely.
I don't know that though. I'm not gonna say that I don't know for sure.
Okay.
I can't say that man did that intentionally. I can't say that for sure now.
Right.
Can't say that.
Well, you can, because he placed something in there that was not confirmed.
But did he do it intentionally?
Hell,
if this is
But
true,
it was done. It was done. You know.
But I'm saying y'all say intentionally as if it was done with some type of maliciousness. You know,
malice.
Yeah.
I don't know that. I mean, I don't know that, because that would assume that man has something against, R. Kelly. I don't know. I don't know. I can't say that.
Can we say this then? If that was a mistake in the case, and there are other mistakes that probably exist, can we at least put that on the table?
That can be some mistakes in the case. Yeah. I don't.
It's
But
not.
which one are they though? Because I don't hear nothing about no BOP emails. I don't want to hear nothing about no.
Going to that. Let me say two more things, and I'm gonna drop down and let y'all talk. The other thing was, when she came in and talked about his abuse that he suffered, I didn't see no typing in the chat. All I saw was people quiet. They didn't talk about his abuse, him being a victim of abuse, the whole mental health information, and I can't wait to go over it. I ain't seen nobody typing. You all have not you, Angie. You people who don't like him have no sympathy for him. You give him no sympathy for being a victim of sexual abuse, but you want us to care so much about the alleged victims in this case. I can't understand it. I cannot. And that shows me that you all have a personal vendetta against him only, because it's not adding up. But let me go before I get upset. Get him, Levi.
Yes, ma'am. Well, I'll say this. There's a difference between, when you say mistakes, we all can make errors. To err is human. But there's a total difference between mistakes and design words spoken by the conspirators. Design words spoken by the conspirators. I'll give you an example. Prosecutor Kim Fox did not make a mistake when she chose to put up a 1-800 number, or whatever number she put up, asking people to call in if you've had any incidents involving R. Kelly. Simply due to a docuseries. That's not a mistake. That is conspiratorial. Normally, once someone is caught, a serial killer or something, or a rapist in a certain area, once they're caught, DNA confirming that they've been in that area, then the prosecutors someone like Kim Fox will put that person's information up and say, look, if this guy climbed through your window, or if you had someone climb through your window that fit his description, or peeping Tom or something, give us a call. So, you know, all that I'm seeing is in line with what I've been seeing and what I've been warning my cousin of, but I have to do it a certain way because I'm a very positive person. I am someone who has always wished for the best, but prepared for the worst. And when I hear you, Miss Walker, and others, you know, even Miss Bonjean, well, she has to do that, but when she continues to say, to note the word fairness, listen, y'all, while I am eternally optimistic, I was telling someone today that I couldn't fight for my cousin if, you know, they kept asking me the same question, and I said, I don't even ponder that. I don't ponder that. I don't even allow it to process in my mind because I'm the kind of person that if I have to walk 1,000 miles and someone says, when you get there, you know, what you're expecting is not going to be there, I block that out. I'm going to walk 1,000 miles, especially for someone that I love. However, what baffles me is that I understand Ms. Bonjean's position, but when you're asking for fairness in a process that has not been fair from the beginning, a process initiated by unfair individuals with an agenda, including that particular judge. I mean, for the love of God, like I said, I will remain optimistic, but I operate from a standpoint that anything he can hit him with, including life, he's going to do it. He's going to do it. There's no fairness. You know, Cus D'Amato was one of the greatest boxing trainers in history. And Mike Tyson, he's never really sat down and really compiled the knowledge that Cus D'Amato gave him. And if he were to do so, it would be a very insightful, enlightening book if he was just to sit and really chronologically go through that. And I know Cus D'Amato was a very profound man in his thinking because I've heard Mike Tyson speak about him. And if you notice, Mike Tyson's a very intelligent man. And Cus D'Amato was a philosopher as well as a boxing trainer. But when Mike Tyson was locked up for that so-called rape case, one of the interviewers asked him, so do you think they're going to let you out early? And Mike Tyson said something that was one of the most profound pieces of life's advice that I've ever heard. As he said in prison, he said, you know, I think about Cus a lot, Cus D'Amato. I think about him a lot. And one thing he taught me is that a person don't knock you down unfairly to pick you back up. If they leave you in the ditch for dead, that was their intent or intentions, and you could expect they will never help you out of that ditch. You have to crawl out of it yourself. So this misplaced notion that Robert is being subjected to a process, a judicial system. We say judicial system, but the judicial system is run by operatives and individuals who control the system. And without a doubt, their number one job is to maintain white supremacy, that which was established, from day one. And, these systems, Ms. Walker, I always tell people, if you went in your basement or went somewhere, came home and you saw a spider web in the corner of your room, you go get your Raid or get the spray. But one thing when you see that spider web in the corner of your room, you're not going to question whether or not a spider has been there. You're not going to say, I wonder if there's a spider in the house. No, you see the spider web, you know the spider's been there. So I say that to say that the system that we speak about, that JoJo speaks about and intelligent people speak about, the system, be it judicial, religious, political, this whole system, its construct is such that just as a spider spews a web, they spew the system. They spew that system. They spew that spider web. So I say that to say, when I was listening to you read, I'm saying Ms. Bonjean is doing what she's supposed to do. She's addressing the legal aspects, but at the same, I'm gonna be quiet and listen to you. But at the same time, when she talks about Steven Tyler and Mick Jagger and all of them, Elvis and all of that, and she points out how none of these white celebrities, who were not only accused of having sexual relations with minors, those under 18, but some of them married them. Shit, some of them literally married them, had kids by them. When she points that out, trust me, that falls on deaf ears with the judge and the prosecutors. It falls on deaf ears. They can give less than a damn about that because this whole thing has been nothing but a conspiracy. So I say all that to say that I'm not expecting no relief. Listen to me. I have to say this while it's on my mind. I'm not expecting the judge to offer him any relief because that's just how I am. That's just how I was raised. I don't, when someone has shown me unfairness or someone has shown me how vicious they are, when someone has shown me how cutthroat they are, I speak with you on social media, but most people I do not. I don't answer their goddamn questions in a chat. I give less than a fuck what they say about Levi, the questions they ask me. I'm gonna tell you why. Because every motherfucker on YouTube.
Oh no.
And I gotta say this on that note. I'm tying it in to the judge. Every person on YouTube, when my cousin was beaten and could have been bludgeoned to death by a pencil, every person on YouTube in this R. Kelly sector saw his brother come out and say, my brother said, thanks for the support, but don't go back up to the MCC because it's just it's just disrupting, it's disturbing the place, and it's bad on him what y'all are doing. And y'all heard that super fan and these terrorist leaders say, fuck you, crackhead. We going back because we want to be on the shade room. We trying to get media attention. We trying to get cash apps. We trying to be seen. Fuck, if they kill them, they kill them, basically. And this is why I have no respect for 70% of the people that's in this shit. I had to say this to tie that into what I'm saying. This is why I don't have an ounce of respect. Fuck y'all. Not Ms. Walker. I'm talking about that 70%. 30% are decent people, sincere people who really want to see R. Kelly receive justice. But that 70%, that can confirm with their own eyes and ears and see a man who raped his own goddamn daughters. Let me say this. And they make excuses for it. The goddamn rogue ex-police fucking security guard, fake ass nigga, is best friends with a nigga who raped his own goddamn daughters. I mean, really? I have to say this. Nothing. A bunch of nothing ass people. And he's supposed to have children himself, but he's friends with a man that he know. Nigga, you want to investigate Levi? Huh? Levi's relationship with his cousin? No, I got an assignment for you. Find that goddamn baby killer's daughters, since you're an investigator, and go out there and talk to them. And ask them if what they put on Facebook is true. Did he fucking rape y'all, bitch? Excuse me, Miss Walker. I got upset because I'm sick of it, the hypocrisy, and these goddamn low-life rat roaches motherfuckers. And it brings me back to the judge, because I've known that what Ms. Bonjean just displayed and what she's asking for, searching for a sympathy and an empathy and a benevolence that doesn't exist in that goddamn courtroom. You're trying to appeal to people that they don't give a fuck. Just like these people on YouTube don't give a fuck. They will sit, the grease-faced woman in the Carolinas, and defend a man who they know raped his own goddamn daughters, who they know there's not a child in the world who would accuse their father of something like that and then be descriptive as they describe what they fucking went through. So it's all a bunch of low-life motherfuckers. It's all a bunch of heartless people. A bunch of what I refer to as animals. These are animals. I heard Mr. D say she cried when she found out what them girls said about their father. I heard Mr. Deese. I was watching her. She said, I cried. That this short, big-nosed motherfucker sitting up in front of y'all and knowing, and everybody knowing that he violated his daughters. And it ties into what you said earlier as it pertains to how you don't like Chicago and the corruption that exists in Chicago. I've been there for him. I got some serious shit going on for him. Because yes, they throw caution to the wind. They have a devil may care attitude when it comes to motherfuckers like the baby killer, where there's an open a case of statutory rape. Now I'm trying to show you the corruption that leads all the way back to this federal court. And what Ms. Bonjean is asking for. I've been to Chicago and had to employ an attorney I said, you take care of that. Because no way in the fuck a person gonna have an open case of statutory rape. You just read documents where Ms. Bonjean was talking about case law. I think she said one of the guys, whoever was 20-something. Listen, man, I'm almost 30 years old, impregnates a 14-year-old. My cousin ain't got no children with the DNA running through their bodies, confirming that he impregnated a fucking 14-year-old. Ms. Bonjean says it. She says a lot of real criminals have violated children, but they just walking around. She said it, so to speak. But what I'm trying to get you to see, Ms. Walker, the YouTube streets are no more different. They're not different than these courts, than these prosecutors, than these so-called investigators and law enforcement. If you listen. When you're white, you can get results. But when you black, you have to press forward. And I am one who never gives up. Listen, I don't give up when it comes to my cousin. I don't give up when it comes to these fucking terrorists. But I said all that to say, if you follow my track record, and really, if you're honest and you look at my track record, I've always played this as a game of inches. I knew it would come to this where his attorney would be pleading with the courts. I knew that. I knew it. Pleading with the court, giving up certain concessions and saying, well, you know, this is this and this. I can show you videos where I said it 2 years ago. I can play a video for you right now 2.5 years ago when I predicted this shit. And now here we are, you know, and he's in this situation. And he's in this situation because in part his moral actions, questionable legal actions, unfit legal representation. I ain't got to go down that road. You know what I mean? He's in this situation because of individuals being allowed to hijack and to infiltrate his case. Listen to me. Such to the point. This is some serious shit, Ms. Walker. This man is facing the big L. Listen, man, this is serious. And one of those who infiltrated and hijacked his cases made it known. I'm going to fly from New York or drive from New York to Chicago to go in and ask R. Kelly, why did you, is he your cousin? Man facing life in prison. I gotta say this. But that's the same motherfucker. I'm trying to show you something who was standing there with his attorney. With the black attorney. Part of the team. Pretending to, or at that point, acting in an official capacity. But now you fast forward, he's convicted, and now you're on fucking YouTube threatening his cousin, saying it's going to end bad for me. And you become so incensed and outraged that you say, fuck that, I'm about to go back up in here illegally, pretending that I'm still a part of the legal team, pretending that I'm still acting in an official capacity so I can get to him for what? To ask him about this tall, black, handsome motherfucking nigga that I despise because I'm a short-looking Shrek motherfucker. And then you threaten me. And I'm really not supposed to even be saying what I'm saying because I took care of business. I'm swift with the gift. I took care of business quick when he threatened me. I took care of business. But I'm trying to show you, how did my cousin have a chance, Miss Walker, if he had these kind of sick people around him? How did he have a chance if he had these kinds of people around him? These are sick people. And when you're fighting for your life in a legal situation, you need the best of the best. You need the most consummate professionals. You need people who don't violate laws, their ethics, their principles, their rules, and they're on the job, they're on the case. You need those kinds of people. But look at the people. He's no different than the pap smear lady who wanted to, if she could kill Miss Denise. Y'all don't get it. That woman was speaking to Miss Denise. If she lived down the street from her, Miss Denise would have to watch herself. That's how the vitriol and hatred that spilled out of her for Miss Denise. God damn. Compare the pap smear lady, what she said to Miss Denise, to what this security guard posing as an investigator said to me. And then someone writes on my wall or something, y'all should quit all this fighting. This, that. What the fuck you mean y'all should quit all this fighting? You see somebody start some shit with someone for no reason at all, they turn around and pull that thing out on their motherfucking ass and say, nigga, what? And now you say, oh, that's wrong. You should, nigga, I will go to the ends of the earth, motherfucker. You fuck with me for no reason, nigga. I'm gonna tell you this, listen, you fuck with me for no reason, you gonna lay in bed many a night saying, why did I fuck with that nigga? Because I do not stop.
Leave that.
I just don't. I'm sorry, Ms. Walker.
No, that's okay. But let me tell you what you're gonna have to get to the point. I'm gonna tell you where you're gonna have to get to the point of. Now, this is just friendly advice. You're going to have to get to the point of that you're going to have to ignore it. I know you probably saying, I know you like, I know she ain't saying that, but listen, because this is what I think is going to happen. I think that the people who worry about you and tell all them lies and say you starting shit when you ain't said shit about nobody, whatever. And a minute, these people kept coming this way. I believe their brain is going to finally just shut down, or they're going to drive themselves crazy. You understand what I'm saying? And if they become as crazy as to come and pose physical harm to you, then you know what to do. Your next step is. Other than that, you're going to have to just listen. Let them. I got motherfuckers in fantasy lands and all kinds of shit. It's a whole bunch of shit. I mean, and you just have to ignore it and just like, Lord have mercy. I don't know what's wrong with you, baby. What's wrong with you? What's wrong with you? And then you can't engage because you don't want all of these type of people associated with you in no form of fashion. You're gonna have to cut it off at some point. You're gonna have to ignore it.
Yes, ma'am.
Yeah, I know you're probably like, what? I'm telling you.
Ms.
There ain't
Walker,
no way. Huh?
we had several shorties up under us who were we had graduated high school, so they were just starting high school, so they were up under us. And in our area, they looked up to us. And I'll tell you this, man, I can tell you as we all got older, I could tell you two of them who niggas started shit with. And I was always the kind of person where I knew that it was a scrap, they over there scrapping or whatever, a squabble. And we would play cards all the time outside because we lived on a corner house. And we was just them G's. We just played cards. Our rides would be parked on, lined up, and we'd just be outside playing cards, drinking and chilling. And I would always when I knew something was going down, I would always pull them to the side. And I could tell you two incidents where I told two younger cats, so you over there, you got into some shit with the niggas over there in other side of Joy Road? Yeah, I heard. Well, look, don't go over there for 3 months. Just stay on this side. I wake up on a fucking Sunday morning. He dead. He gone. I'm trying to explain something to you. It's from a virtual YouTube, social media perspective, I get what you're saying. I get it. But when you come from my world, threats are like a person putting a gun up to your fucking head and cocking it. I'm being honest with you. That's just how I grew up. I swear for God, Miss Walker, you don't even hear niggas in Detroit threatening money. Niggas in Detroit don't threaten. They just don't do it. Bunch of talking.
Yeah, we don't do that either. We don't
Yeah,
do
just
that
threatening
either.
and shit. No, you don't do that.
Happen. It's something gonna happen, but
something gonna happen.
A lot of these people, they dealing with a whole bunch of issues, and you got to realize if it's their issue, then you can't do nothing about it anyway. If it's mental health, you can't do nothing about it. If it's jealousy, you can't do nothing about it. If it's envy, you can't do nothing about it. If they want something you got, shit, you can't do nothing about that either. You can't do nothing about it. Now, with the exception of threats, I can understand what you're saying with threats. That's something totally different. But there's a lot of stuff you just gonna have, the system, the law, we're gonna have the shit that meets those standards. But with these crazies, there's nothing you can do about it. If somebody says, you got to be crazy. If I show you W-2s and shit with bears my name, and then you come back and say that I'm unemployed, something is wrong. That's a whole nother different problem. That's nothing you could correct. And listen, and look who you're arguing with. Look who you're going back with. People that can't pronounce words. People that putting extra syllables in words. People lack comprehension, understanding. I got motherfuckers that think they are in some relationships with but fantasy life. It's all kinds of shit. There's nothing you can do with these people. You got to understand that. I'm trying
I get
to
it,
tell you.
but you must.
How long can you argue? Because after a while, you're gonna be looking crazy.
Miss Walker, I'm sorry. Go ahead. I'm listening.
Somebody is going to have to call the cops or the crazy house if people keep arguing with people that ain't arguing back with them. You look crazy as hell.
Miss Walker, you don't come from my world, and I don't fault you. Everything you're saying is true on a normal basis, but
yes, I do. Kind of, sort of.
No, everything you're saying is true, but you have to understand something, Ms. Walker. One of my close friends, I would consider him a close friend, acquaintance, was a man named Benny Napoleon. Benny Napoleon, if you Google his name, was the lead Wayne. He was police chief, and he was the head of Wayne County Sheriff, the Sheriff's Department. Benny Napoleon. Stand-up guy. We met under crazy circumstances because my world, we don't like police, but he and I met, and it was the craziest shit. It was crazy how I would see him, he would see me. I was very popular, but Benny Napoleon, stand-up guy, the women in the city loved him. But Google him. Light skin, long, what they call good hair, that kind of nigga. You feel me?
Yeah.
And he could tell I didn't like him. Make a long story short, we met by happenstance face to face, and he asked me. He said, "What's your problem with me?" And I just looked at him like, "What do you mean?" However, we became pretty close. And Benny Napoleon said something to me that applies to what I'm saying to you. We would have countless conversations. I being anti-police in a sense. And he was interested. And when he decided to run for mayor of the city of Detroit, I was unofficially one of his consultants, unofficially consulted him and for him. And he would just call me and, he's running for the mayor of the city of Detroit and up against a white dude, Mike Duggan. And he valued my opinion. He valued my insight. And when we talked about rogue fucking law enforcement, and the FBI had probed him, probed the police department, the Detroit Police Department when he was with it, and they had him caught up in some stuff. And, he was a good guy, though. He was a stand-up guy. And he said to me one day in Midtown, I think we're in Midtown, and we were having lunch, and he said to me, Levi, he said, remember something and tell your niggas, basically, tell your niggas, I see how you talk. I see how you lead them. I see how you are anti-corruption. You just hate that shit. He said, but remember something, man. You cannot win in the streets against the police. You know me. Quite naturally, if something went down, I'm a vouch for you. I ain't gonna let nobody touch you. I know you're a good guy. He said, but remember one thing, and I want you to listen to me, Ms. Walker. He said to me, corrupt officials, he said, I'm in it. I'm at the head of this shit. Corrupt police officials and corrupt individuals who have access to law enforcement are some of the most dangerous, he said, dangerous individuals on the planet in any society. So he said to me, he said, I'm going to give you some advice. If you're pulled over, you say, yes, sir, yes, ma'am. Go on your way. If you pulled up, and that man talked to me and changed my fucking life because I looked at it totally different. He said, because you can't win against them in the streets. Now, you can win against them in the courts, but you can't win against them in the streets. So that instilled something in me. And it caused me to see, when I see a dude that used to be an ex-police commissioner, and I know he has ties to corrupt law enforcement, ain't no way in the fuck on life am I gonna take a motherfucker threatening me for no reason. For no, you targeting me, nigga. You'll never target me. Listen to me. I had to take that to federal law enforcement. I had to file an official complaint there and in the goddamn streets. On my right hand to the Most High God, I had to take care of that because he has connections to rogue law enforcement who are the most dangerous people in any society, like Brother Benny said. These are y'all can take this YouTube shit lightly if you won't do it. Go ahead, but because you're not me.
No, I didn't say. I said, you know, when it comes to threats and things of that nature, that's something totally different. But I'm talking about just the people that you would never talk to offline. You know, I wish I could play more of this conversation between me and my friends, but you know, we were just talking about, like, you know, our real life, right? You would never talk to these people offline. Not, and I'm not talking about, I'm not, I mean, y'all know the ones I'm talking about, the ones that fall upon disclaimer number 2. Now I got another disclaimer, number 3. You would never talk to them. There's no way in hell. Where you gonna talk to them at? Where you gonna run across them at? So if you know you would never have a conversation with them, why even acknowledge them? Let them acknowledge you, honey, in their life or something. I don't know what it is, the fascination, but I ain't never been fascinated by no regular person. I don't really nobody at all. Like, God damn, it's crazy, right? It's almost like having a disgruntled fan club. Like, well, God
yes,
damn,
ma'am.
Did you not get the what is it, the love packs? What the things that people send you when you send your college, get the what you call it? Did you not get the signed T-shirt? Like, what the fuck is going on? It's like, you know how Eminem had that song Stand? Like, these are stands and shit.
Absolutely. Some sick people.
Fucking stands and shit. What the fuck? Like, what?
Well,
weirdos.
Yes, ma'am. Yes, ma'am.
They have their perception of you in their head and your life and everything that goes on because they thinking whatever. I'm like, oh my God. And my thing is, if I'm the worst of the worst, well, then I shouldn't ever be on your mind. Then let me be that. Let me be the worst of the worst of the worst. Oh my God.
Yes, ma'am. Yes, ma'am. Yes, ma'am. And you, everything you're saying is right. But like I said, I don't play when it comes to rogue law enforcement. I don't play. I just don't play with them. And at the same time, I'm prepared to give my life. You feel me? I'm prepared. Listen to me. I'm prepared to die for this. And when everyone saw it. When that Storm interview with my cousin just set that shit off, where this man pulls to the side of the road and says it's not going to end good for me. It's going to end bad for me. Nigga, there will be no existence. I'm going to put it to you like that. There will not be any existence. It will be no existence. It would be that old question that has been in existence throughout the annals of history. Throughout the annals of history, man has asked that one question: what happens when it's over? And I swear for God on my life, in self-defense, if I trip over a motherfucking sidewalk, he gonna know the answer to that motherfucking question. I'm gonna tell you why, because I don't bother people. I mind my business. Now I want to clear something up, and then I'm gonna get back to my cousin, but I have to clear this up on this note. The baby killer said, well, you said he's a dangerous man. If he's a dangerous man, why you fucking with him? First of all, he fucked with me, for one. For two, I want the baby killer to know, you got to understand something, baby killer. You ain't never in your life, even in the streets of Chicago, you ain't never in your life met a motherfucker more dangerous than me. Remember that. No. This is my right hand to the Most High God. You ain't never in your life met a motherfucker more dangerous than me. Because the most dangerous motherfucker on the planet is a motherfucker that don't mind dying. You understand? I want to make that clear because they try to play with words. If he's so dangerous, I don't mean dangerous as if he's, as an individual, he's dangerous. He's pussy as an individual. But when you're connected to rogue law enforcement, that makes you dangerous. I don't give a fuck who you are. And I'm just, he say he know my name, but he's proven that he doesn't. Because if he did, I swear for God, if he knew me, he wouldn't dare sit there for no reason. I'm minding my business. Miss Walker, you saw it. I don't even think about these people. I'm helping my cousin. This man, just for no reason, just lost it because my cousin confirmed I was his cousin. But I don't want to get off. I've been talking about that too long. Getting back to the reading of what Ms. Bonjean submitted, I'll say it again. She's doing her job very well. And we know, and Ms. Walker, you know, all she wants is for the sentence to run non-concurrent. That's all she wants. Because if she's successful in that, then once she's successful in the appeal, it just makes it a much easier road. Would you agree with that? Are you there, Ms. Walker? You might be muted, Ms. Walker. Oh, you might.
Yeah, I'm here.
Yeah, I wanted you to explain to the people from a legal perspective, if Ms. Bonjean can get that judge to not run the sentences concurrent, how would that look in the appellate process of what she's doing in New York and eventually in Chicago? What describe those two different roads? If he runs it concurrent, and if he, how would that look as she faces these appeals? And if he doesn't run it concurrent, how would it look? What's the comparison? And I'll be quiet and listen.
If she runs it, like she said, concurrent, or if he runs it concurrent, you know, if it's something he gives within 30 years, and you know he'll do whatever, you know what I'm saying, but at the same time, but you know,
I misspoke. I'm sorry, I misspoke. She wants him to run it concurrent, correct?
Right.
Okay, right. I misspoke. I want to clear that up.
She wants him to run it concurrent.
Absolutely.
And you know, so and if he don't, it'll be consecutive, and she'll just have to file 2 appeals. You know, and then if that don't work, then it'll be 2 2255s. I just hate that Chicago is so all over the place because I can't get a sense on shit. I can't get a sense on what the PSI said. I mean, you know, only just in one area. I can't get a sense on nothing. And it's so unfortunate.
I had another question for you. I meant to ask you earlier. Why do you think they concealed the PSI?
They can always seal it because it has personal identifying information and all of that. They always conceal it.
They can't redact.
Yeah, but it's
We had access to the
yeah, but I
PSI in
mean,
New York, right?
no. I had to guess at that. I had to guess at that.
The
Yeah.
PSI in New York, um, her response to it. Wait a minute. The PSI in New York, when they said that he admitted to certain things, Aaliyah, he admitted to certain things.
That was her. That was her opposition to the PSI, and that was also in their sentencing submissions. The PSR is
Absolutely.
going to be is going to be sealed always.
Absolutely. However, we basically had the PSI in New York down pat, right?
Yeah, I had to guess at it. Yeah, from what
No,
they
but
sent
it
in.
was exactly. But what I'm saying is that it was enough revealed where we had it, or especially you
Right,
had it
right,
down pat. Now, I'll
right.
say this. I think for what you read earlier, as far as the abuse, or it was a big issue that she addressed concerning the what's the word? That he was basically making them do these things, and she was highlighting how he wasn't.
Right.
Um, I think what the PSI is saying is that they're relying upon his age and him being in an authoritative position. You feel me?
Mm-hmm.
And they're saying, from what I gather, that alone is like he's making them do it because he's the adult, he's the authority figure. You know?
Right. On the sentencing guideline on the table, on the application used to calculate that, you do get points for when you are in when it comes to this sexual abuse crimes or sexual exploitation or whatever, crimes like that. They do give you you do have an area where they give you points for or extra months. Let me say it like that, for when you are in a person in authority, when they consider you a person in authority, right? So I think on the
Right.
last one in New York, they considered him a person in authority. So that can so you're right when you say they look at that as saying you are in authority. So and a threat, as you heard me read it, doesn't have to be by physical force or by you know threats like that. You know it could be, it don't have to be coercion or anything like that. That's crazy. You
Absolutely.
understand
Just
what I'm
some.
saying? So she is challenging the language, which is what she's supposed to do. She's challenging the language of the law. So and I mean and she's asking the judge to make an interpretation even of I think in some areas, I believe, even when it comes to mandatory law, which is some of the wording in the Constitution, but um, so and some of the other laws. So
Okay. Now,
it's
when you um the 2255, when you said she would have to file two, right?
right, right. So if just say if both of these appeals don't work, right? When it gets to that point for New York and Illinois. If either one of them don't work, she'll file 2255 again because that goes back to the trial judge. So
Got you. I
either
could have.
yeah,
I'm sitting here. I could have swore that I could have swore I read the PSI report. I got to go back to that. I could have swore I read that.
no, it's sealed. It's sealed because I was like I had to think about it. I said those things are sealed. I don't know how that because I did it on my live. I was like I don't know what the hell I'm thinking about. So that shit is sealed. And but yeah, go back and look.
I could have
Go back.
swore I read the one in New York.
Mm-mm.
Yeah, but as far as Chicago is concerned, Miss Walker, listen, man, it's the Wild Wild West. You see that? It's the Wild
Yeah.
Wild West. It literally is. It's the Wild Wild West.
But I want to know. Now, here's the thing I want to know, right? Because I don't know this answer. Can he justify, if that is not correct, can he justify keeping that at a category 3 like that, even though it wasn't a conviction? And hold on, you know what I'm gonna do? I'm gonna go see. I'm gonna read. Hold on, I know what I'm gonna do, because I can't sit up here and just go to sleep on that, because I don't like that. I don't like bullshit. I don't see this. Hold on. Okay. Um, okay. Because I want to know, can they use? I want to know, can they use that? Because she said, because she didn't use the language. Hey, you can't use that shit if it ain't true. She didn't say that.
Absolutely.
She didn't
Absolutely.
say that. So that's kind of
Oh, somebody wanted to ask you about it.
concerning
Go
to
ahead.
me.
Yeah.
Oh, go ahead. I'm looking through the document. Go
Okay.
ahead.
Another thing I wanted to people to pay attention to. If it's interesting how she brought out. Well, she said Sparkle was the one that stole the damn tape.
Yeah. I was like, oh. I was like, oh.
and she points to, in a sense, she's suggesting culpability. Like she stole it and didn't take it to law enforcement. She put it out in the damn streets. Okay, so I want to ask you, what is the difference? This may open up a whole different can of worms. Comparison wise, what is the difference with what she said as it pertains to Sparkle not being charged and having? I'm glad Skylife is here because I want her. She's perfect for this. If Ms. Bonjean points out to the court, Sparkle was the one who originally stole the tapes, didn't take it to law enforcement, but basically she was responsible for the tapes being out there in the streets.
Yeah.
And then she notes she was never charged with distributing child pornography that they say is child pornography. What's the difference between that, Skylife, and the parents of Jane Doe number 5 being culpable and they were not charged? You follow me, Skylife?
I do.
Huh?
I do.
Oh, Lord.
However, they should all be charged. I don't see how. Do y'all hear that?
Is that my phone?
What?
Like some wolves or something outside my room.
It says the wolves
Y'all hear that?
or birds.
Yeah, but ain't no wolves, girl.
Coyotes or something.
Yeah.
Lord, y'all.
It might have been, it could have been at nighttime. Sometime those geese fly past. Like it'd be like 50 of them.
See the geese or some coyotes, that was scary. But I
Oh, Lord, J-Bo. Oh, damn.
What?
J-Bo, you in that pencil, girl. Listen what it says. This is what it says. It says the guidelines assign each offender to one of 6 criminal history categories based upon the extent of an offender's past conduct. Okay, let me go a little deeper. Go ahead. Because, see, when it's left open like that, conduct don't necessarily mean convictions. Damn. Hold
Yeah,
on.
but he alleged that he pled no contest. That was his thing, right? Reason for giving him the point. Then he say he was uncertain whether or not he pled no contest.
And Levi, look at this, and then I'm gonna hop back out of here. I
Mm.
came up here because y'all was talking about my city and my people, though. That's why I came up here.
No, we weren't.
Can you tell us what's
No,
wrong?
I was talking about the government there, Scott. The
What's
government.
wrong with the people?
No, I'm
What's
gonna be
wrong
honest.
with them? I
I'm
don't know
gonna
what's
tell
wrong with you.
y'all, and I'm gonna be honest. Every single one of us, bloggers, R. Kelly, everybody from Chicago, we all got it honest. Okay, now we all display things in our own particular way, and I mean I can't not put my name in it, you know, but we got all of it. Whatever we got from Chicago, we got it honest. That's all I'm gonna tell y'all. But let me say this, and I'm gonna go. Sparkle matches the Mama Clary, because remember the testimony of the young lady. She stated that she told me to go to him and tell him that I wanted him to be my godfather.
Right.
No different than Mama Clary. Okay. And I'm out on that note. I'll catch
All
y'all.
right. I feel you.
Identification of multiple guidelines. Conviction based on each other. Offense become applicable guidelines. Being shared with applicable base guidelines. Indicating second three. Additional subtraction of offense per section instructions circumstances. Wait a minute. Addition, subtraction of offense levels per section instructions for the circumstances in case of a hand. Add subtraction of offense levels per instructions of guidelines related to victims related role of the obstruction counts acceptance responsible. Okay, criminal history score. Wait. Okay, so wait a minute. In between the guidelines, establish a series of escalating sentencing range based on the circumstances of the offense and the criminal record of the offender. The offense and the criminal record. Let me keep digging. Go on, Levi. Hold on.
Okay. Also I wanted to say that something else, Bonjean, she pointed out, early on she pointed out that let me think about what that was. It was something I wanted to touch on. Dang, I forgot. Bottom line is this. You know, I'm prepared for the worst. You know, plain and simple. And what Ms. Walker's doing right now, it only speaks to what JoJo says all the time, and that that is, it speaks not what you're doing, but what you're researching right now is what JoJo talks about all the time, and that is the people who established the laws are the same exact people who broke every treaty with the so-called Native Americans. Not 99%, 100% of the treaties that they were signed, they broke them, right? Secondly, you look at the Trail of Tears and how the treaties were written, certain laws should not be subject to interpretation. You understand? The Ten Commandments sent down by God himself, the Ten Commandments were not subject to interpretation. Shit, thou shalt not kill. Now, hold on.
That is crazy, because that means that the law would be perfect as written. That you are contradicting yourself.
Let me put it to you like this. What they accuse people of is very perfect, and it's how they accuse you. How they accuse you, the word I'm looking for is not subject to interpretation. when they charge a person with fucking murder, they don't put no disclaimers in there. They just say murder. You're charged with the crime of first degree murder, premeditation. Boom. Now, you can't stand up in court and say, Your Honor, I would like to challenge the definition of premeditation. You can't do it. Like premeditate, you knew what you were gonna do and you did it. So, but they're very tricky when it comes to how they do what they do. Now we have to interpret what you're saying, and now and let me address this, because I was gonna jump on that train, Ms. Walker. I couldn't let that train pass.
What train?
I understood when she said double jeopardy. I get it.
Yeah. Oh no. Oh no. Oh my God.
I got I understand. I understood what she was saying, but it is double jeopardy.
Yeah.
And while you were reading, I said, this is double jeopardy, because I thought about something. Well, let me ask you a question, Ms. Walker, as it pertains to double jeopardy. Was every accusation, since we're talking about how we interpret things, right? Wasn't every accusation as it pertains to Miss Landfair, wasn't every single accusation that was contained in the 2008 trial contained in this last trial? Yes or no?
Yeah.
Didn't they revisit everything from the 2008 trial?
Yeah, I think that and more, yeah.
And more, there you go. So, but however, if you want to talk about interpretation of the law, if you want to talk about the imperfections, if he was being charged with obstruction, now I'm asking you a fair question now. I want you to think about this. Why wasn't everything just about obstruction? If you're charged with obstruction, the sex thing shouldn't have had shit to do with the trial. We just charged you with obstruction. How do you go into, so when was the first time he touched you and all that? No, we talk about obstruction.
Because you want me to give you the legal? Because I'm going to give you. Because they went back, they charged him in a different jurisdiction with a different charge with different elements. That's how you get around double jeopardy.
I understand. I always say that it was a legal violation of double jeopardy. I always use that term. It was legally done, but the objective starting out was to bring them back on the same charges. That's all I'm saying.
Yeah.
You feel me?
Yeah.
Oh my God! Thank you for agreeing with me.
Bring back on the same charge, but it's not double jeopardy. But to bring back on the same, bring back on the same act, because what different charges? So I like to be correct. Bring back on the same acts. Those pretty much are the same acts.
I'm gonna put it to this way. Let me tell you something. I was taught something because he asked me when it first broke. He asked me. He said, "Isn't that double jeopardy?" I said, "Yes, that's double jeopardy. You ain't got to worry about that." I told him that. I said, "No, they can't do that. I'm a purist and shit, and thinking that the law is cut and dry." It taught me some shit, because when it happened, I couldn't believe it. I could, but once again, this is what JoJo said.
You ran around him, boy. When we was doing them debates on Larry, I was like, "Oh my God." They knew in the chat. They knew if you said, anybody said double jeopardy. Oh my God, they know my goddamn fucking pressure head. Like, no, stop saying that. It drives me crazy.
Well,
go ahead.
In all honesty, I pushed that envelope. You saw me push it as far as I could push it, right? Listen. I pushed that double jeopardy envelope as far as I could push it. But what did I do when I got to the end? I said, well,
You
you feel me?
started on the, you started on the BOP emails.
Absolutely. Absolutely.
You start on the text messages. Shit, you start. I'm like, oh my God.
Absolutely.
No.
Well, and once again, that's the key. The key is to challenge every step. It's a game of inches. And one must challenge every step. If you fail to do that, you're inadequate. And I'm not his legal defense, but from the outside looking in as a layperson who loves him, I'm going to look at it. Man, listen, y'all don't even know. That's why I was so upset when Keith said, I didn't know the paperwork. And let me tell you something about me. I never told you this about me, Ms. Walker. I never said this on YouTube before. Isn't it strange, and maybe is it just me, but I have to have, the reason why I have boxes of the paperwork, like literally boxes at my studio, like boxes. For some reason, I have to have the tangible document in my hand to really, you feel me? I'm not comfortable with reading off the screen. Are you?
You know what? That is so, you are crazy. Wait a minute. That must be some more Virgo shit.
You the same way?
You know, I had to make myself comfortable. You know, I used to have it in my hand too.
Yeah.
I was like, wait a minute. This ink shit ain't working for me. This ink shit ain't working out for me. Okay? Because now I'm at the house. I can't just run to the company's copier. Hell, I'm the company. So, yeah. So, and it took, that's why sometimes I be stumbling and stuff. I be moving all around. I be changing where I be having the documents and stuff. But I like to have, let me tell you something. I like to have stuff in my hands right now. I will take my taxes to the people because it's all confusing. But with my daughters, because it's so simple, I'll file it. She, email me the tax return and stuff like that, or she'll email me the tax return or whatever. I print them off and have them in my hand. I print stuff off and have it in my hand. Like it's a couple of pages.
I have to. I
have to have it in my hand.
Me and Larry be on the phone, listen, preparing for the debates, and we would go over certain documents, and we would be looking at them, and I would say to him, okay, let me call my girl or whatever, so she could, because at work, she can print them. You feel me? But she was printing. Yeah, she could print them at work. So I'm like, let me call her and shoot her there. I would just be shooting them to her. And he would be like, why you got to have them printed? It's right on the screen. I said, man, I can't read that. I got to hold it.
I used to yell at Robert Keller. Robert Keller used to blow my phone up with the document. I said, Keller, please send them to my email. So at least I can open them up and goddamn see them or whatever. Because I could read them better now on there. So I've gotten used to it now. Everybody else knows to send the stuff to my email stuff. Robert Keller would blow my phone up. I'm like, I don't know how y'all do that. I really can't do it on the phone. That ain't working.
No, that ain't gonna happen.
That ain't working. People be doing it. I mean, people be doing their life. People be doing their work on their phone. Are you crazy?
I can't do it.
I can't do it.
The kids, the kids, like my daughters, they're used to it on the phone. They be doing all their work on the phone. Like, how do you? I can't do it.
I have to. Everybody knows to send the shit to my email, because if not, I be like, I can't see it. I can't. Or sometimes people just send me stuff to my phone or whatever. I just go and send it to my email, all kinds of shit, because I can't. Is so crazy. I put that stuff in my hand. Like,
and I have to print documents. I have to print them. You feel me? I just have to hold it, lay them out, look at them. I have to touch it in order to really be comfortable in consuming and digesting it.
Yeah. Go ahead.
Oh, it was something else she said in there. Well, I just cut through the chase. What is your prediction as it pertains to the sentencing?
I can't get a sense of if she's saying, because see, I thought it would be I said I was saying about 30 years can concurrently, if this is what I first said, concurrently, um, if at the lowest, but consecutive maybe at the most. I'm all over the place with him. But now when I look at this, when I'm trying to get a sense of this PSR, I'm I don't know if they're saying that the government is saying that the because see, the government's part isn't in. It doesn't mean that they haven't seen it yet. It just probably ain't dropped in pacer yet or something like that. Or
Right.
they, maybe they got on the phone or whatever. But if I'm not mistaken, and I know I ain't crazy, because I think she said the government's calculation is from 14 years to 17.5. Now, most times they agree with the government, right? When they sentencing. Now, I don't know if they have that added on there saying, if the government's saying, but they would feel comfortable anything north of 17.5. See what I'm saying? Like they did,
Hey, but how Miss Bonjean writes now. You feel me? You know how she
Yeah,
writes now. She'll project onto the government now. she
yeah,
she writes in such a way where it could have been, well, even from the government's calculation. You feel me?
yeah, because exactly. It could be some,
Yeah.
hey, Levi, and the government submission will come out in 50 years.
What the fuck, right? We have so damn poor, right? Nah,
J-Bo
yeah.
don't give a damn.
Yeah,
J-Bo
her
like
right
shit.
style is like that.
J-Bo
Yeah, that's
don't
her
give
right
a
style.
shit. Yeah, J-Bo don't give a shit. The government, I be like, we ain't said that.
Exactly. Exactly. When you
We ain't
read it,
said,
I said that. I said, yeah, she's probably projecting, like,
yeah,
you
I'm
know.
like, now, I don't know what I said, this thing mighty low. That's why I was saying, and I kind of changed it from my board. I said, look like y'all getting a break. I'm like, I don't know about this. Something don't seem right. Because they
Right.
were pissed at that podium that they lost those other counts. They wanted the whole goddamn thing.
They sure in the
And they
hell
did.
did.
And I know how prosecutors act. They lost they lost what, 7 counts? That's a loss to them. They
Absolutely.
won, they lost. Yeah. They lost. Ain't they lost more than they won? Oh, no, 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 no. That's why. See, you gonna make me go back in here and look at this thing. Because I'm serious. You make a good point. She would pistol whip some shit.
In a
And you
minute.
know it.
In a minute.
You know it.
In a
I'm
minute.
telling you what the lady said. I'm like, this don't seem right. This
In a
don't seem
minute.
right. J-Bo don't give a damn. J-Bo like she be hanging out with the brothers. Like J-Bo says, the defendant's guideline range for this instant case is 135 to 168 months imprisonment, not the 168 to 210 months as the government argues. Now hold on, let me see. Okay, now that corresponds to footnote. It says the range is certainly not as probation contends, where probation clearly did not read the testimony of the complaining victims, ripped much of the PSR from the EDNY case and demonstrated as concerning bias where it attributed a criminal history point to Kelly based on an unsourced internet. Hold on, wait a minute. Levi, I think you're right. This is some bullshit. Hold on. Hold on. Because the range is certainly not as probation contends. Well, what does probation contends? Because
Exactly.
listen, I look, because that's on a level 32. Both of those ranges. Hold on, let me put up the sentencing guideline. Hold on, let me put up the chart. We can look at this chart right now. And somebody sent me the New York the New York opposition, and it's much cleaner. So I was able, yeah. So the comparison is day and night between that and Chicago. Oh my God! Didn't I tell y'all Chicago? Where Karen J at? Didn't I tell you Chicago was gonna get in my ass when the first paperwork? I said, I don't like. I already don't like this shit.
Man, please. Can't nobody tell me. In Skylife, I wasn't talking about the citizens. I'm talking about the people. I got some real good people in Chicago. Real good people. I was talking about the government, how they run things is just fucked up. It's like, and I'm not going to say this. It's just the Justice Department, how they do things. I found to be absolutely absurd how they just do things, man. Straight up, unbelievable.
That's my Skylight. Skylight, where you going, Skylight? That's me, Skylight. Let's say it like that. Okay. No, that's 2006. Is that the latest? Why would I have the latest? I need the latest. Latest. But that's crazy. Something ain't right about this. You right.
Yeah. So you're not comfortable at this juncture saying what you think the judge is going to say?
I'm gonna tell you, I honestly would. I wouldn't have a clue based on how this man. Okay, this 2021. I wouldn't have a clue. I thought because they call him the lifer and all this shit him whatever.
Right.
I would feel better when I see what the prosecution is asking. If I see exactly what the prosecution is asking, then I'll feel a little better.
Right.
But this shit him. Okay, what level I said it was today? Okay, there he go, right? That is. She says she's on. Yeah, can y'all see this? Is it up? You see it?
Yeah, I can see
Levi?
that. Yeah.
Okay, so that's criminal history 2. Okay, criminal history 2. That's the category. All right.
Yeah.
Level 32. That's at 135, 168 months. She's saying the government. Wait a minute. Got him on level 4. Wait a minute now. Cause wait a minute. Is that the PS? That's the PS. Hold on. Is that the PSR? She said not the 168 to 210. The government article. Hold on. So that means it's a level down. Hold on. Oh no. The government must be got him at a 35. The government or wait a minute. A 35 or a 34. Or 33. No, it's a 33. Because he got three he got three levels. So it's he's on level 33. But damn, is that she said as the government contends, she says that.
Right, exactly.
The government argues. She says the government argues. Yeah. I don't know about that, Levi. I'm like you. I don't know about that because she could easily be saying that shit, hell, based on what the government said during the trial, and if she goes about what he said during the trial, based on the indictment, it may range from 168 to 210. Because I was wondering how the hell she know what the government argues. But they ain't dropped nothing yet. Hold on, let me make sure. Let me see if it's in there. Is it sealed? Because she'll be able to see it. Only, when it's sealed, certain people get have access to it. Hold on. Because this don't make no sense. How you know what the government argues? You still there, Levi? What happened? Oh, Levi gone? Let me see what happened. Just one of them days. Yeah, the New York one is much cleaner. Okay, let me see something, y'all. Okay. 411. Okay. Well, I guess I can read this motion for miscellaneous relief. I'm sorry. So, this is, let me read this. This is about restitution. What's up, Mr. Wonderful J? Is this it? All right. It says government's motion to defer the calculation of restitution. The United States of America by John R. Lauch, Jr., United States Attorney for the Northern District of Illinois, hereby moves pursuant to Title 18 U.S.C. Section 3664 D5 to defer the calculation of restitution in this matter until approximately 30 days after sentencing to allow time for the victim's losses to be fully ascertained. In support of the motion, the government states the follows. 1. On September 14, 2022, a jury found the defendant guilty of 6 counts of the superseding indictment to include counts 1 through 3, sexual exploitation of minor 1, Jane, in violation of 18 U.S.C. Section 2255A, count 9, enticement of Jane, in violation of 18 U.S.C. Section 2422B, count 10, enticement of minor 3, Nia, in violation of 18 U.S.C. Section 2422B, and count 12, enticement of minor 5, Pauline, in violation of 18 U.S.C. Section 2422B. 2. In light of defendant's convictions pursuant to 18 U.S.C. Sections 2259, 2429, and 3663A, the court must order restitution to the victims of these offenses in an amount determined by the court. 3. Defendant's sentencing hearing is scheduled to proceed on February 23, 2023. 4. On January 24, 2023, the government submitted a victim import spreadsheet to the United States Department of Probation and the court on February 3rd, 2023, and the government submitted a supplemental version of the offense regarding restitution to probation. As set forth in the supplemental, the government has received some information related to the restitution amount. However, the government is in the process of obtaining additional information. Number 5, pursuant to 18 U.S.C. Section 3664 D5, if the victim's losses are not ascertainable by the date that is 10 days prior to sentencing, the attorney for the government shall so inform the court, and the court shall set a date for the final determination of the victim's losses not to exceed 90 days after sentencing. 6, as the Supreme Court has stated, the procedural provisions of the Mandatory Victims Restitution Act reinforce the substantive purpose of the act, namely that the state seeks primarily to ensure that victims of a crime receive full restitution. Case law. 7, because the amounts of the victim's request for restitution has not been finalized, the government requests additional time beyond the February 23rd, 2023 sentencing hearing to allow for the victim's losses to be fully ascertained. The government has conferred with defense counsel who objects to this motion. Oh, she objects to it? Oh, shit. Wherefore, the United States respectfully requests that the court grant the motion to pursuant to 18 U.S.C. Section 3664 D5 and defer the calculation of restitution in this matter until approximately 30 days after sentencing to allow time for the victim's losses to be fully ascertained. J-Bo objects to it. She tied. Okay? Y'all, what I wanted to look at. Oh, wait a minute. Y'all, let me look at this New York, thingamajigger real quick. Okay. Yeah, I'm trying as best as I can to try to get a understanding, trying to get a feel of what could be possible sentence. Cause see, if it's, but if it's 14 to 17 and a half years, shit, y'all cooking with gas. And it could be like that. So it could be come out to maybe, it could do, like maybe like 20 or something like that. If he not being this lifer man. Now, will he run that concurrently or consecutively? That's the question. But see, this New York work is clean. The one that this other one, shit, I can't. Hell, I can't put my finger on it. Oh yeah, defense prescription. The defendants objects to PSR, concluding that enterprise existed. But y'all see how she's trying to get them to consider that the Illinois it has the same structure as RICO. They just didn't charge it. And that's so crazy because I was talking about it and I said, Liz, they could have brought those charges from Illinois and put it in on New York. I said, but no, they just wanted to make sure he stays somewhere in jail. So they, hey, we're going to put it in this jurisdiction and put it over here too. The CYA, I think I used that term to cover their ass. And J-Bo picked up on it too. Ain't that some shit? I'm trying to see y'all. Okay. I ain't gonna be able to get an idea. So, I mean, listen, if the government, would they be that close in range? No, but okay, but she's not going to be okay. Her calculation would probably be close in range like that to keep it fair. Because if you look at how she hold on. Damn, I'm gonna open this back up. Every time you click on this shit, it charges. Check this out, y'all. Check this out. She can be close. Okay. She can be close if she's doing her job, right? She's saying that that's the benchmark. Damn. I don't know where I want to go with this. 'Cause I hate this. I don't like to get it wrong. I don't want to get it wrong too much anyway. But it says, now y'all, come on, think tank. Come on. It says the guideline sentencing range is 135 to 168 months imprisonment. Defendant's guideline range for the instant case is 135 to 168 months imprisonment, not the 168 to 210 months. Hold on. Let me look at something else. Hold on. I might have caught it. All right. She says 135, 168. Okay. She's doing a level 32 with 2. And they're doing a level. This might be the government's number, y'all. Y'all might get a break, Team Kale. Because this is on a level 3. A level 3. I mean, a category 3. I'm sorry, and a level 33. This might be y'all break. As the government argues, the range is certainly not as probation contends, where probation clearly did not read the testimony of the complaining victims, wrote much of the PSR from ED in the New York case and demonstrated concerning bias with and it used the New York case. But then what is the goddamn? The PSR ain't gonna be higher than come in higher than the government. Unless now the government either saying it's either 33, level 33. Damn, I hate Chicago. Or a level 33 or level 34. If they're agreeing with J-Bo for the category to be 2, then it's a level 34. If they're agreeing with the PSR, and see, they can, because listen, what did I read to y'all about the criminal history? The defendant's criminal record. A defendant's criminal record may be of consequence under the guidelines for 2 reasons. The record. Now, if it was expunged or if it was dismissed, dropped, or whatever, then there wouldn't be a record. But, let's explore this. Let's see, we can at least figure this part out. How they're going to break with regards to this. Because check this out right here. Because this is important. Because this puts this man in another category. All right, let's read what she says about the damn Louisiana man, the cop. Hold on, let me keyword Louisiana. Baby. Okay, here we go. Louisiana. Okay. Y'all come on, think tank. Come on. Listen. Defendant and the government agreed that Kelly's criminal history category is a 2. So they must be do got the government shit. I think y'all got a break. Team Kels. I think y'all got a break. I think y'all got a break. Listen, I'm awake now a little bit. Listen. I know I read it, but let me, It says defendant and the government agreed that Kelly's criminal history category is 2. Probation contends that Kelly's criminal history is 3 because an unidentified internet source reveals that he pled no contest and received unsupervised probation in 1997 in connection with a simple battery charge. Probation admits that it has been unable to obtain any court records that reflect Kelly's plea of no contest. So if there is no record, because see, if there's a criminal record, then it counts. Then 3 would be right. But if there's no criminal record, then it should be 2. And they should correct that. And it says, in connection with simple battery charge, probation admits that it has been unable to obtain any court records that reflect Kelly's plea of no contest, his sentence, or proof of how the case was resolved. Instead, it relies on an unsourced internet article containing information that was allegedly obtained from pleadings in a related civil case. Probation cannot even identify the internet article on which it relies. Is this the man that the cop man that he said R. Kelly broke up his happy home and shit? It says critically, Mr. Alper, who prepared the PSR, contacted undersigned counsel earlier this week and conceded that a law enforcement representative from Louisiana informed him that the arrest and disposition from the 1996 Louisiana arrest was expunged, meaning it shouldn't be a record. But Mr. Alper has yet to amend the PSR to reflect that Kelly should not receive a criminal history point from this incident, since expunged convictions cannot be counted toward criminal history points, meaning it's not a criminal record. Okay. Says, okay, so she's saying that the government says that he's a category, he's a category 2. So that puts me back to where I was. If he's a category 2, then he's a level 34. And listen here, y'all got a break. Y'all got a break. Chicago showed them some love. If that's what they're saying, but I don't know what the asking is. The asking could be, higher. But if that's the calculation, y'all got a break. Let me come on around there where y'all at. Hey, big baby Pernell, what's going on? Hey, how you doing? Hey, what I said, what the joke I made about the free R. Kelly people? I said, I could be just sitting here, and it could be Tasha K on talking about Trey Songz, and I see somebody from this sector, one of them R. Kelly people, and before I know it, I see it scroll up, free R. Kelly. I be like, boy, man, they serious about that shit. Boy, y'all go in. On the Darrell Brooks trial, I seen somebody from this sector type right on in them people chat, free R. Kelly. I was like, damn. Hey, I can't take y'all nowhere. Oh, I can't take y'all nowhere. Oh man, seriously, straight up and down. That shit be so damn funny. I be watching that shit. I be like, look at that. There was somebody from the sector. I done seen somebody on Mr. Junior's page, but that person was from Oco. I seen that on Mr. Junior's page. Y'all know old man Mr. Junior. Oh, I love that man. That man's so damn funny. I love him. I like the cussing pastor. I'm serious, y'all. I sat up there and boy, it could be anything. You don't want the people from that goddamn sector. Free R. Kelly. Oh, I'm like, these niggas is serious about they fight. But that, you know what? Listen, the government, when they elicits and solicit, I should say, people, I ain't gonna say they do that. I ain't gonna say that. But when people are fighting for, a particular cause and the government is representing that side, they call it a whisper campaign, right? And of course the defense can do it too, but they call it a whisper campaign. And what they do is they do just like the goddamn barbs, just like the beehives and all them people and shit. They go around, whether it's on foot, whether it's on social media, however, and they fight for their cause. They say free whoever they trying to free. They, talk about, you know what I'm saying? They take whatever opportunity when they see a camera, they really see a camera. And they call that a whisper campaign. Mm-hmm. Yeah. It'd be funny as hell, though. That should be funny as hell. Hold on for a minute, y'all. Let me see if I can play this. Hold on. Yeah, started with the. That's how. Yeah. Oh, that's how she got out of jail. Yes, that whisper cam. Yeah, it works on either side.
Black Emmanuel.
Who?
You know what she ran? You remember the cinematic movie Black Emmanuel?
What's that?
Bueno, it was soft one.
Oh no, I don't know nothing about that.
Yeah, you know about Black Emmanuel.
I don't know about no Black Emmanuel. What shit is this? Black Emmanuel.
And you know nothing about Magic City either, did you?
No, you so goddamn had them people looking at me stupid. I'm some fucking Magic City. You so fucking stupid. You always embarrassing me.
I wasn't there.
Yeah, but you know I don't know nothing. And I don't know none of that shit. You were talking about Andy. Tell the people to take up there to Magic City. And I'm in there with all them good people. All them good 100,000 and good church people and stuff. I was like, hey, you was on the phone. You just, I was like, hey, can y'all take me to Magic City?
Oh man. Oh man.
You people were looking at me like, oh God. You sure she's one of us? I'm like, fool, what is that? Yeah, they got quiet. And you on the phone hollering, laughing. And I'm like, what is that? You talking about that strip club? I'm like, you motherfucker.
Like Eddie Murphy said, Brother Johnson, one of our most faithful members. You were down there with a $2 hole.
That's so damn. I got to upload that. I got so much shit to upload, y'all. Y'all gonna die. Y'all hear about? Oh Lord, yes, honey. He told me in front of all them good people. Told me to ask the people and see. I don't know how these two people picked up on my. I'm cool. I'm part of the cool kids. However, I do have a degree of naivete. Okay. I did not know no goddamn Magic City was. This ain't been too long ago. I know no damn Magic City was. Magic City. I thought it was somewhere, the name sound like an amusement park or something. I done asked some people to take me to Magic City. And honey, when I tell you the room got quiet. Oh, wait a minute. I might have something to play. Hold on for a minute. Let me see. Thank you, Miss Thing. Let me see what this is. That shit was funny. Magic City. Hold on. Wow. Somebody want to put down on the rights to all this, that, and the third. Let me see. Oh, I hope he let me play it. Oh, yeah. I seen, I saw he had this, but I didn't play it. I like him though. Okay. Oh, y'all do the can y'all somebody do the disclaimer? Oh, well, let me put my official one up. Hold on. Okay. Y'all, when I tell you I miss my hanging out with my people and stuff like that, but that's going to change. But I miss that shit. Oh, I miss it. Okay, where is it? Okay, here we go. Okay. All right, YouTube, I do not own the right to this music. Lord, this video. This is a criminal defense attorney. Um, last name is Curse, I think. I'll put. Hey, can you put the link in the chat, please, and so people can like, share, and subscribe to his channel and his video, please, so I can play this. Please don't strike me, sir. This is for educational purposes. Okay, please don't strike me. Let me play it.
There are 20 million reasons he deserves a new trial. Let's talk about it. My name is Jamal Kersey. I'm the principal attorney at Kersey Law, a boutique criminal defense firm in San Diego, California. And last week, R. Kelly's lawyers, they filed a motion for a new trial in the federal court in Illinois. They argue that R. Kelly's due process rights were violated when Jane, the prosecution's star witness, basically lied during her trial testimony on the topic of restitution. Now, if you didn't know, victims of criminal activity are entitled to restitution. And basically, restitution is compensation for a victim's losses. So in a vandalism case, the victim can recover the cost of having their wall repainted. Or in an assault case, a victim can seek to recover the amount that they paid in hospital bills as a result of their attack. So back to Jane, right? After Jane's direct examination testimony, when she was questioned by the prosecutors, she sat for cross-examination. And R. Kelly's lawyer had asked her if she had been informed that she would be entitled to restitution if R. Kelly was convicted. So on cross-examination, you are seeking to attack a witness's credibility, their bias, or their perception. And so in this situation, the defense was basically seeking to expose that Jane had a motivation to say any and everything that she possibly did in order to make sure that R. Kelly got convicted and basically that she would get paid, right? So Jane had actually confirmed that, yes, she knew she would be entitled to restitution. And so the lawyer asked, all right, well, you are entitled to restitution. Will you be seeking restitution if R. Kelly is convicted? And she said, I'm undecided about that. No, actually, that's not correct. And so the lawyer gave her a chance, probably just being stunned that she would give that as a response. She said, wait, you haven't decided if you're going to seek restitution? She said, no. So Jane playing of her seeking money on the other side of a conviction would stand to kind of add to her credibility, right? Okay, well, I'm just tell the truth. I'm just here seeking this. I'm not going after money, right? I know I can get money, but I'm not really worried about it. Then it just makes it look like she's telling the truth. But get this, before Jane cooperated with prosecutors, her and her family retained a law firm out in Boston. And so their lawyer was the one that reached out to the prosecutors to negotiate immunity agreements for Jane and her parents. And on top of that, he helped with retaining an expert team to put together a restitution package. So prior to sentencing, if there's going to be a request for restitution, the prosecution will submit any documentation in support of a victim's restitution request. So apparently the prosecution in this case provided documentation in support of Jane's restitution request, right? Remember the same Jane who said, I'm not sure if I'm going to be asking for restitution. Well, get this. There was a 9-page letter asking for $20 million in restitution. Jane paid a team of experts $10,000 in order to put together this request for $20 million in restitution. The crazy part about this is Jane's lawyer's billing records show that he was in conversations with the government regarding Jane's restitution as early as April of 2020, a whole 2 years before Jane took the stand and testified and said that, I don't know if I'm going to be requesting restitution. So Jane clearly listened, and now I know there's a bunch of folks that are going to be in the comments talking about that's not the only thing she lied about, right? But we're just focusing on this one for now. R. Kelly's lawyer further argues that not only did Jane give false testimony on the topic of restitution, but the government knew that this testimony was false and they didn't correct it. They completely failed to address this issue and correct it. So when Jane was playing it cool about not seeking restitution, knowing that she was going to ask for $20 million, the government had a duty and an obligation to correct that record. The government should have disclosed Jane's intent to request this absurdly high amount of restitution, but they didn't. They allowed her to sit up and lie and deceive the jury regarding her motives and interests. And make no mistakes about it, Jane's credibility was very vital and crucial to the government's case. The jury really needed to believe Jane regarding key points of her testimony in order to make a conviction against R. Kelly stick. Therefore, naturally, the defense should have had an opportunity to expose Jane for the big bag she had invested 10 stacks to obtain. Curious to see how the judge rules on this motion. Let me know what you think. Should be a lot of response to this. Do you think R. Kelly should get a new trial based on this revelation? Let me know in the comments below. And if you're getting out of this, please show me love and hit the like. Make sure you subscribe to the channel and turn on those notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.
It's just certain things, just like riding a bike. He stopped on the same thing I stopped. And when I went to, when I scrolled down and I went back to look at the damn, see if there was some dates. Yeah, he stopped and saw the same damn thing. Dates. The paper had dates. Like, how you gonna get out of that? And they up there talking, oh, I'm glad you sent me that, because that ties in with the government's 30 days it needs to calculate, right? Recalculate Jane's tuition. No, you need 30 days to come up with a fucking response to that goddamn motion. Boy, when I tell you, them goddamn, them people, that legal system, and the legal system is powered by human bodies. That goddamn legal system up there, they about as bad as I am. Shit, I barely goddamn graduated. Shit. What's their excuse? That's crazy. Because they knew. It's just like, it don't matter what side you're on. Some things are, just basic fundamentals that we learn in school when we got out. And and shout out to SpongeBob. It'd be so goddamn when somebody be up here with some sense, especially in your goddamn area. That is what's good with it. What's good with it, J Rock? Especially in your area. Okay. Especially in your area of expertise. That you can kind of talk about this stuff on a more elevated a more elevated basis, right? And so and then for the record, I don't think SpongeBob know how this shit is operated over here. It's rough over here, honey. So I don't think he took no offense to it. Like I say, people come over here. I let people come over here to curse me out, and people get up here and they talk about other people. You know what I'm saying? So, hey, I'm me myself. If I'm bold enough to talk about people, hey, should be able to talk about me. If I don't want nobody talking about me, shit, I should simply shut my goddamn mouth. But that still don't work, because even if you shut your damn mouth, motherfuckers that got head problems and shit, mental health illnesses and all kind of other bullshit going on, still gonna talk about you. And look like a damn fool when you ain't talking about them, but that's neither here nor there. But I think I think we had an excellent conversation about just some basic things with regards to the law. And I was glad to have that procedural era conversation with them, being that was centered around that motion that J-Bo filed. So shouts out to him. SpongeBob. Yeah, honey. But anyway, so as you see, make sure y'all, I think Karen put it in the chat, the link to Attorney Curse. I think it's Kersey. Chat, so make sure y'all like, share, and subscribe to him. He went and looked at, he stopped and said, oh, he said pretty much the same thing I said. Now, I don't know about the new trial thing, because I don't think that's going to, I think it's going to be a remedy for that before it even, gets to a new trial. But I know Levi is somewhere. That would be next on his goddamn list to push. You can believe that if he ain't already got it going in the goddamn in the newspapers, honey. That's gonna be Levi's next. Now Attorney Kersey done said it that R. Kelly needs a new trial. Lord have mercy. I don't know what I was thinking. Hey, when I heard him say that, I should have cut it off, because Levi gonna pick it up and run with it. We ain't gonna never hear the last of that. Hey, a black attorney said it. Oh, it's over for us now, y'all. It's over for us. Oh. But yeah, I just don't believe they are going to think that I don't think the judge would find that it's in the interest of justice to even order a new trial. Shit, but when it comes to Chicago, who knows? Don't let me go the line. Who knows? Because I don't. I really don't. I really don't. Because listen, it is a procedural error, and that's a mistake that happened during the trial that could have prevented someone from having a fair trial. I'm trying to think before Levi runs with that. Or he might stay on the damn emails, honey. Who knows? You might put Halen Alexander. Oh, thank you. Main reason Kim Fox dropped the charges because the state trial had the possibility of being televised and she didn't want her off. You think so, J Rock? Oh, J Rock, you be talking good shit. I be you one of them hitters on Vice channel. I believe I done heard you. So I heard you there on Skylight, one of them. I think it was Vice channel. Yeah. So when I think about that, let me think now. I don't know. Maybe that's what whatever, Mr. Wonderful J. Seriously, think about it though. Think about it now. Now, Attorney Kersey says that that's a good that he deserves a new trial. Cause listen, but he is a defense attorney. Okay, let's keep in mind. And when I was reading it, I did agree that you got to have fairness on both sides. It did hamper her ability to cross-examine that witness, as how should I put it? That did hamper her ability to cross-examine that witness in order to make her testimony less credible and challenge what she says. You know what I'm saying? So, it did. They didn't know anything about it. Because asking about do you expect to receive well, wait a minute, let me take that back. I thought he just said, oh, wait a minute. Damn, wait a minute. It might be fucked up. Hold on. Because she said, do you expect to get any money, whatever? Oh, okay. Yeah, you know what? Because let me think on level 2, y'all. I'm sleepy. You know what? Because when she went once, Jane Doe would have given her response. If J-Bo would have had that information on paper, but wait a minute, what is this? This clearly states that you expect to receive some type of restitution. Yes, that could have made her look all kinds of ways, on that stand, showing that she, could not be trusted. She got that's a pretty good challenge. Hey, Angela Jackson, you back? Him in Chicago, let him go. Yeah, because those are 2 different jurisdictions. Yeah. Hey, y'all. So let's work up this procedural error. Lord, I'm talking y'all like y'all in class. Let's see. Let's see how let's see what the remedies are for this procedural error. Let's see. Hold on, let me get into my stuff. 1 minute. Make sure I don't have it up there. Hold on. Okay, let me read this directly from an appeals court attorney, okay? From Hascott and Majero, the one that was over there on Sylvia's, right? You know, he's a good one from Florida. And I told you, when these situations come, you need an appeals attorney, okay? Let's read what it says. It said, what to do about procedural and legal errors. So you're unhappy with the way things went in court and you want to appeal the decision. If you take an appeal to a higher court, they will look over the record made at the trial for procedural or legal errors. Even if everything was done wrong in the trial, you still need an appeals lawyer to handle the process right. I promise you, I'm reading this right off his page. Okay. It says, if you've lost in trial, or if you're unhappy with the part of the trial court's decision, you need to speak to an appeals lawyer. First of all, it's not inexpensive. You can run tens of thousands of dollars in fees. Blah, blah. Wait a minute. I just need to get to the answer. Okay. Let's see. Many people want to appeal a court decision just on principle, but sometimes a fine you owe through a court ruling will actually be less than the cost of appealing the decision. A good appeals attorney for my okay. No, I need to answer. Wait a minute. Okay, in the case of a criminal conviction, there's a hope that an appeals process will overturn a conviction. Above all, consider the post-conviction relief is sought after for a good reason. The stress of criminal convictions, especially if the trial was full of errors and the outcome came out wrong, denotes a reason to seek a remedy. Okay, if legal procedures or actual errors occurred during the trial, a criminal conviction can be overturned on appeal. It's a good idea to contact an experienced. Okay, well, how would you get around that one? Hold on, y'all. I'm trying to find something. Shit. Good. All right, let me read this one. Team Cash, y'all got a little fire, little hope. Now, I mean, if that thing, if that sentencing guideline is right, 14 to 17.5, that the prosecutor said, that per J-Bo, and Attorney Kersey said that R. Kelly need a new trial in the same case based on that last motion for a new trial that came out. Let's see what this attorney says. Let me read it. It said, our appeal courts showing more mercy for procedural errors. Let's hear. It says a handful of cases over the past 5 years have seen Pennsylvania appellate courts taking stand against the judicial practice of tossing out otherwise meritorious cases on procedural technicalities. But attorneys said it's still an issue as both trial and appellate courts continue to battle heavy caseloads. Furthermore, attorneys said there is a lack of consistency in how much forgiveness appellate courts are willing to extend to parties for procedural errors. Maureen McBride, a partner in the litigation and appellate department of Lamb Erlene in West Chester, PA, said in an email that she believes appellate courts have been willing to overturn lower courts' rulings where procedural missteps put one of the parties out of court, but she added that the court's generosity is not always meted out consistently. We see plenty of cases where strict adherence to the rules, particularly with regard to the rules regarding waiver, is applied to the great detriment of one of the parties, while in other cases, the court appeared to be more sympathetic to the plight of the parties by forgiving a technical misstep. McBride said in the email, I think for the predictability purposes, it would be helpful for the courts to clarify when and under what circumstances technical errors will be overlooked. As an example of a case where the appellate court was willing to excuse procedural issues in favor of allowing the parties to have their day in court. McBride joined to the recent unpublished Pennsylvania Superior Court opinion in Jones versus Mercy Suburban Hospital. In that opinion, issued January 31st, a 3-judge Superior Court panel unanimously ruled to reverse Montgomery County Court of Common Pleas Senior Judge Authority R. Tilson order dismissing a wrongful death and survival action and remanded the matter for trial. Judge Ann E. Lazarus, writing for the majority, said that even though the case was more than a decade old and trial had already been delayed several times, Tilson abused his discretion by dismissing the suit when there was no evidence that delaying the trial again would prejudice the defendant hospital and doctors. Hold on. Lazarus called Tilson's order troubling and said it placed justice second to arbitrary compliance with procedural rules. Okay. While we acknowledge that the delays can be costly and inconvenient for both the courts and the parties, they are not a reason to deprive either party of its day in court, Lazarus said, calling it troubling that Judge Tilson dismissed Jones' case because it was old. This court has repeatedly held that a court's legitimate interest in controlling its docket should not unnecessarily infringe upon a litigant's right to a trial. Lazarus said, adding that Tilson's decision to dismiss the case on a technicality placed justice second to an arbitrary compliance with procedural rules and constituted an abuse of his discretion. Wow. The legal tenet that courts should not place strict interpretations of procedural rules ahead of justice is not a new one. The state Supreme Court ruled in the 1972 case Budget Laundry versus Munter that courts must bear in mind that lawsuits are more than numbers or punches in computer cards. Individual cases are, of course, of great importance to the litigants involved, and courts must not overreach in their zeal to move cases to such extent as to allow for no deviations from the strict and literal adherence to policies justifiably laid down to improve the condition of the court. The Budget Laundry Court said. In 1979, the High Court held in Dublin Sportswear versus Charlotte that the quality of justice must not be subordinated to arbitrary insistence upon compliance with procedural rules. But Pennsylvania attorneys said they believe increasingly busy courts often attempt to lighten their caseloads by looking for procedural defects to weed them out. Oh, it says McBride said she does think heavy caseloads are contributing factors to some courts' less lenient attitudes towards procedural mistakes, but she conceded that the procedural rules are necessary to keep the courts running smoothly. I think that there's a lot of utility in holding people to the rules. McBride said, I think we need to do that for efficiency's sake. John J. Hare, chair of the Appellate Advocates and Post-Trial Practice, y'all, I'm sleepy as hell, group of Marshall Dennehy, Warner Coleman, and Goggin in Philadelphia, said in an email that appellate review of procedural dismissals tend to be, what is that? Oh, I'm sorry, fact sensitive and case specific. Our appellate courts tend to review procedural dismissals closely because, in general, they don't want litigants to lose their day in court based on what may be seen as technicalities. Har said, however, in appropriate, see, I took my glasses off, y'all, I'm sorry. However, in appropriate cases, and especially where a party has no legitimate excuse for violating a well-settled rule, the appellate courts certainly do affirm procedural dismissals, even if it means putting a litigant out of court in a significant case. Still, McBride said there needs to be more guidance as to when courts will be willing to overlook procedural defects and when they won't. Okay, I'm not going to read all that. And, oh, I'm getting cross-eyed. Wait a minute. Yeah, that's a good one. Damn. I'm give me a minute, y'all. I'm just looking for one more. Let me see about this one. Hold on. Hold on. Okay. Hold on. Okay, Freddie Miller. Man, this might be. Hold on now, right? This might be because see, it wouldn't. So you can raise this also on a 2255 as well. You know, yeah, I'm sorry because now I got to follow this. Wait a minute, because I'm about to go to sleep. Y'all see I'm sleepy. Hold on. Wait a minute. They say the shit cannot be permitted to stand. Hold on now. Shit, hold on. Okay, but let's look at this one. Okay. Just as it may be unrealistic to expect that the most subordinates will never make an accidental misstep in following directions, so too proposing and deciding officials can err when performing the procedures for implementing adverse actions. However, most procedural mistakes by proposing and deciding officials can be fixed. Some of the procedures to implement as adverse actions as come to regulations from some statutes, and some are the result of court decisions by employees' constitutional rights. The procedure type can determine the consequences for the agency's failure to follow instructions. For example, by statute, before removal, employees are entitled to notice of 7 days to women. Okay, 7 days. However, the notice and response opportunity is also right under the Supreme Court interpretation of due process clause of the United States Constitution. See, they raising due process and all of that too, and the Constitution. That's mandatory law. Okay, wait a minute. Because the notice and response right substance owed to the person by the government, they are substantive right. Yep. Oh shit. Even though the substance in question is a specific activity, when a right is substantive, the individual is entitled to have it right, irrespective of how little influence the right may have exercised on the government's decision to act. An adverse action that violates a substantive right cannot stand. That's what they teach. Oh shit. In contrast, I'm just trying to see if there is a remedy before a new trial can be ordered. Like, what's the list of remedies? Okay, that's what I'm looking for, y'all. So I'm sorry I didn't tell you that, but I'm just trying to see. In contrast, a procedural right has to do with a set of processes. It is more about the system than it is about the person using the system. For example, the statute for removing federal employees states that the action will not take place for 30 days. The waiting period is a procedural right. When the procedural right is violated, an adjudicator must perform an additional analysis to determine the remedy. Okay, there was the remedy. This is known for, all right. Remember I was telling you about the harmful error test? Okay. Remember I spoke to y'all about the harmful error test? Spoke to y'all about that test a couple times. Okay. Here go. I know the bullshit was down up in these remedies somewhere. Okay. So there's a certain thing, remember I was telling you about, I'm sleepy, y'all, I'm sorry, about the harmful error test, what's a harmful error and what's considered to be harmless, okay? So let me just read it directly from here. Okay, this is known as a harmful error test. Under this test, once the non-substantive procedure error is found, for the action to be reversed, the appellate must show that it is likely that the error caused the agency to reach a conclusion different from one that it would not have reached in the absence or cure of the error. Meaning, if just say, ooh, damn, she might have a point. Wait a minute. I'm thinking. Because if she can say, well, there's no way really to know now if the jury would have believed Jane Doe, because without that information, she was unable to alter her cross. One part of her job is, but here's the thing, right? Then the prosecutor could probably argue down that, hey, we can't, like I told y'all, we can't say that, that would have been your strategy if that piece of work if that piece of information was provided, well, she can come back and say, well, how do you know that it wouldn't have been? She has just as much right to say, hey, this is probably what I would have done had I known this information. But when I tell you I'm cross-eyed right now, I don't see how cross-eyed people do it. No offense to nobody that's cross-eyed, but my eyes is going. I mean, when I tell you they crossed, y'all. This is crazy. So there is a okay. Okay, hold on. Okay, first I want to read that. Okay, it wrongs is short in the statutory. The board found 8 days because employee and the procedural error. Okay, when an agent makes a substantive error or harmful procedural error, the adverse action cannot, by law, be permitted to stand. If an agency finds that it has erred, it need not to wait for an appeal to be filed for the MSBP to rule that an agency error. Prior to reaching a decision on a protocol adverse action, agencies can rescind the proposal and begin a new constitutionally, and procedurally correct action. Women agents can rescind the proposal. And agency can also cancel the board permitted cure the agency finding the education process. However, if the board cancels the action, substantive procedure errors, the agency can fix those errors by starting over. Oh, they say the agency can fix the errors by starting over. So what I'm using here is this would be something similar as using case law to this particular situation, right? And case law pretty much helps aid and tells you how the law should be applied, right? In circumstances with similar with like similar situations, right? So it says, starting over. It says the board has long held that an agency can renew adverse action based on charges brought on early proceedings where the adverse action in the proceedings were invalidated on procedural grounds. Summarily, if the substantive right is violated, the agency is free to take action. Again, using a constitutionally correct process, that respects the employee's substantive right. The procedural mistakes that agencies make can be fixed if the officials just cancel what they have done and start over, properly following the law. The real mistake is believing that the procedural errors cannot be fixed. Okay, so at this time, since the trial has passed, a conviction is on, and the only way to remedy this, to fix this, it would be a new trial. Oh, no, y'all. Oh, no. Oh, y'all. Oh, what's good with it? What's good with it, JoJo? What is good with it? I will, Linda, but see, I done kind of perked up because, listen. Now, you heard Attorney Kersey say that's new trial material. Now, I ain't saying that you know more than my bitch ass. And y'all heard what I just read. See, when I get started like that, damn, man, I hate I be starting shit when I'm half asleep and shit. Cause now I got to know. Well, let me see. No, this is totally different. Providing the wrong rule or the legal standard Remember I told you about legal argument standards and rules, right? It says the typical grounds of the judge. Hold on, let me see. I don't know, y'all. Let me look one more place because I like to get a collection of different attorneys' opinions, right? So just bear with me. I ain't gonna keep y'all up much. Shit, I don't keep y'all up 2:15. Wait a minute. Yes, sir.
What's the deal?
Now, what's up? They got words in it.
You got
That song got words in it.
nah, man. I don't play words in my songs unless I'm on some street knowledge mission.
What's good with it?
I'm low key out here. Shit. Let the nigga know they can't fuck with it.
Now, what that mean?
What's up? What? Red turned heads, of course.
I see.
What y'all in there talking about, man? I was at the bar. I ain't. Go ahead.
Talking about the objection, her objection to the, what is that?
They did what?
What is that noise? Talking about, Bonjean's
The
objection.
music going on in here. God damn, you say what's that noise?
Yeah.
That's the music.
Bonjean's
Make you wake
objection.
up. Shit. You wanna know what that noise is? That's this noise.
Okay, but you asked me a question. It's okay. You want me to answer it?
You asked me a question. Hold on, shit. I'm pulling up at this light. What's up?
So you asked me a question. Did you want me to answer it?
No, you asked. You said, "What's that noise?"
Yeah, but I accepted music as the answer, and I was giving you your answer as to what
you just sleeping. You sleeping, man. You need to go get you some rest.
Well, I am, but you asked me a question though.
What up, chat?
We were talking about, huh?
I said, "What's up, chat?" I don't know. You know. You need to go get you some rest.
I was going to give you the answer to what we were talking about.
Okay, I'm listening.
We're talking about J-Bo's objection to the PSR report that came out. That's what we're talking about. And then we were also talking about just some of the things she said on there. And as well as we were revisiting the latest motion that just came out. Hey, can you cut that music down or something? Something's going on.
That music is so low. That damn music's on 3.
Okay, and it's something crunching and something like that. Make me sound like Donald Duck.
I don't know what the hell that is.
So
it's Donald Duck.
No cut up no more.
Okay, I'm turning. Hold on, let me leave up out of here. I don't know what the fuck going on. I'm gonna leave up out of here. Let me see.
Anyway, as I was stating. So All right, let me look at one more thing. Okay, one more thing. We're gonna go. Okay, it's something I'm reading that was saying that there were a combination of procedural errors that led to um, a dismissal of the charge, right? So I want to see what the government response is, but I've liked motions before from the defense, and once you see the government's part of and the points they make, of course I have to look at what they cite, you know what I'm saying, what they use to argue, support their argument, right? Mandatory law, some primary law, case law, whatever it is, right? What points they make. But I find it funny that they haven't responded yet. Unless they're waiting to, because they've had the other motion for a new trial, the Rule 29 and 33. They've had the new trial and acquittal. They've had those, they've had those for a decent amount of time. So, hmm. Hold on, let me see how long they had them out. Hold on, let me see. We just being nosy right now. This crazy. Okay. All right. So they've been responded to those. Government responded to those in December, almost a month later, right? It took a minute to respond to those almost a month later. So I don't like Chicago. I'm trying to tell you. So I really can't gauge how long, the expectations would be, what our expectations should be for the prosecution to respond. But I'm telling you, mm, I don't know. I'll wake up tomorrow and do some more, look into it some more. If y'all want me to come back to see if I could, let's see what the likelihood of it would be. Because, of course, I like this better than I like them damn BOP emails, and also them damn text messages, right? I like this because this has an actual legal argument that can be apply. It's a rule. This is an error. There's a procedure it goes by. This is nothing that you have to speculate or whatever. This is no speculation. You ain't gotta make up shit. So I want to see when and Chicago is cheap. They would throw it out first. You think so? I don't know. Because it could be a situation if it doesn't pass that test, they ain't gonna be able to do that. Maybe what about does it apply? What about does it affect just that the charges that dealt with her? How about that? Who knows what the remedies can be? So let me put that down, and I'll see how far I can go with that to see if I can get a good possible scenario of how it play out. You know how we do over here in the think tank. Um, okay, y'all. So I am so sleepy. I apologize if that was a rough read tonight, but I am been tired. You know what, honey? I have so much shit going on. Sometimes, most of the stuff I do, when I work, it's projects, right? But hell, I be working some jobs too. Shit. When I'm independent, and when I tell y'all I be out there doing this, that, and the third, child, those be projects. But shit, I'm tired. Well, anyway, I appreciate y'all coming over to listen. Thank y'all so much. Thank you to everybody that sent me something to read. I appreciate that. Thank you, Purple always. Um, Thank you, Club Blue. Thank you for everybody for coming up. Levi, Skylife, JoJo. Thank you, everybody. I appreciate y'all. And y'all have a nice weekend. Make sure y'all do something for yourself and do something for someone else. All right. Peace out. Love y'all. Bye.